matter?
Yes, Your Lordship. My lord, not the particular prayer against the section 14. They have prayed, my lord, an interim order so that the bank should not take any coercive steps.
Coercive steps under SURFACE Act only?
Yes.
Because if it is not SURFACE, I will not be having determination.
No, Your
Then
Lordship.
Justice Rao will be having.
Item number 2, I appear on behalf of CSC.
My lord, led by Mr. Amitav Ghosh, I'm praying for short passover, my lord. Kindly granted, my lord.
Passed over.
Grateful, my lord.
Time fixing is difficult. If you are not there, you pray for time. I will again grant time.
I appear for the state respondent.
Very good. Call Korun.
Lordship, in item number 3, I am appearing for the petitioner led by Mr. Anirban Pamnik, Lordship. This is our application for implementation of section 14, Lordship.
When was it filed?
Lordship, the order of DM passed on 25th September 2025. Lordship can find at page number 28, Lordship.
You have deposited police cost.
Yes, Lordship.
Police cost deposited?
Yes.
Yes, then why are you not providing him police assistance?
And for the state, Lordship.
Yes, you have to provide police assistance. They have deposited police cost. When have you deposited, Mr. Pramanik?
Lordship, kindly takes page 31.
Page 21.
31.
31.
Is the challan?
Yes. 1311.
Lordship.
Likhen. The petitioner alleges inaction.
May I please, your lordship?
Yes.
Service. Lordship, this matter relates to challenging an order of SCM in respect of an order passed under section 114 of the Service Act. Now, question comes, my lord, the order was passed against my husband, who was the creditor of a bank. He was expired long ago. Thereafter, my lord, I was a widow residing in a premises which is the subject matter of the law. Now, my lord, suddenly the entire matter was passed behind my husband's, and I am not in a position to aware what are the proceeding has been initiated by the authority. Neither 13.2 subsection 2 notice, neither 13.2 subsection 4 notice, neither section 14. Well, I am not aware. Suddenly this, my lord, notice and the order was, my lord, pasted in my wall, front page. My lord, I suddenly come before lordship. I could have been understood that there is any proceeding has been initiated against me before the Surface Act, then I could have been in a different manner. I could have been approached before the tribunal. I have no other option.
Proceeding has not been initiated. If there is a section 14 order, proceeding has been initiated.
My lord,
Otherwise, section 14 order will not
your
be
lordship,
passed.
100%, because you're, I know, my lord, your lordship having the vast experience.
In order is passed, the DM will not pass the order unless he is satisfied that section 13 proceedings have been initiated.
110% your lordship correct, but against a dead man. My husband was expired. Yeah, I have annexed the death certificate. Your lordship, kindly take trouble to the.
Kindly take page 17.
Yes. Lordship.
Seat serial number 3.
Lordship.
Chobi Das, wife of Gopal Chandra Das.
Lordship. Mother.
So?
My.
He is a co-borrower. How is it relevant? The co-borrower is there. The other person is there merely because one of them is dead. Therefore, he will not repay the bank. You go and challenge it before the DRT. Section 14 order can be challenged before DRT.
My lord, I could have been.
Affidavit of service filed in court.
One modest prayer subject to kind sanction. I would like to disturb your lordship at the first session of the court. What I'm pressing before lordship. At least, my lord, the police and others officials.
Challenge it before the DRT, get the order. Not
My lord,
this.
obviously, but in the meantime, my lord.
In the meantime, if I am not exercising writ jurisdiction, how can I pass an order in the meantime? Go and challenge it before the DRT, get a stay. Likhen an affidavit.
My lord,
of
one
service.
modest prayer. In that event, should I withdraw or lordship, your lordship directed me to prefer an appeal before the
No question of directing. I will grant you liberty to approach the DRT in accordance with law.
lordship, your lordship. That should be.
Affidavit of service filed in court today is taken on record. Full stop. The petitioner is aggrieved by an order dated.
ठीक है.
Order dated
My lord, 12/6/2026.
Where do I get the date?
But here, my lord, if your lordship,
Where is the date of the order?
12/5. Lord, just I'm showing your lordship. My lord, page 18, 12/5/2000.
Page 18. Yes. By an order dated June 12, 2026, passed by the learned Chief Judicial Magistrate, North 24 Parganas, Barasat, on an application under Section 14 of the Surface Act. Full stop, paragraph. The petitioner submits that the order has been passed against the petitioner's husband, who is no longer alive.
Lordship, will expire on 5/12/2023.
Who expired on December 5, 2023. Full stop, paragraph. It is noticed that the petitioner's husband was one of the 3 borrowers.
No,
Again-
petitioner is a wife here, lordship.
Petitioner's husband was one of the 3 borrowers who had availed of credit facilities from the respondent bank. Full stop. The who is the owner of this flat?
My husband, petitioner husband.
He is not the only owner. All three of them. Property stands in the name of Gopal Chandra Das, Chobi Das, and Indranil Das.
My lord, after expiry, my lord, subject to kind sanction, what I learned from my client, that the loan has been taken by my husband as his employee. Thereafter, my lord, after expiry,
What is this loan for?
pardon, Lordship?
What is this loan for?
My lord, residential purpose, the loan has been taken from the bank,
House loan.
house loan, where I have been residing,
Serve the bank again and come.
Lordship.
Declan.
So kind of.
Co-borrowers. One of the three borrowers of and under the credit facility availed of from the respondent bank. Full stop. Since none is none of the respondents are represented, comma, the petitioner shall serve a fresh notice on the respondents, intimating them that the matter shall be taken up next on 18th August.
So kind of.
My lord, in item number 3, my lord, I am appearing for the state led by Mr. Purobi Shahadas, learned advocate. For the state, my lord,
Somebody represented the state in item 3.
my lord, represented.
Yes, somebody was there.
Oh, grateful, my lord.
Somebody was there. Yes, next.
My lord, in item number 5, I have been interested with respondent, my lord. One humble submission, my lord.
I may not have determination for
My lord,
It's not
my
a
lord may not have determination, my lord.
It is not a surfacey matter.
Surfacey matter, my lord.
We have determination for surfacey matters.
My
Other
lord.
matters will go to the regular group 9 bench.
My lord.
Lordship, basically this matter I am being led by my senior, who is an outstanding counsel. Lordship.
Right, but I don't have determination. You have to mention it before Justice Rao. I'll release it. This matter does not pertain to surfacey proceedings.
My lord, I'm praying for Passover in this matter. My lord, kindly fixes it at 2 p.m. or at 12 noon, my lord.
12, I have another fixed matter. Cannot fix it at 12.
At 2 p.m. 2 p.m. my lord. My lord, at 2 p.m. I shall.
এটা কালকে 10:30. Don't take time tomorrow. 10:30.
Tomorrow at 10:30.
I'm grateful.
Yesterday she prayed. Today also she prayed. I am accommodating her, but this is the last time.
Going through it, what has fallen from my lord? I was also going through it. But subject to my lord's pleasure, my lord, only for academic discussion, these things came. RBI guidelines in case of MSME, now that is well settled. In 2016 notification, that says only PSU. Now that was subject challenge, but that was all along, it says honorable coordinate bench as well as division bench says no. Although it indicates PSU, but it will cover NBFCs also. Now it is within its fold without rehabilitation process, you cannot declare an account NPA. And so
No, but here it is not
now,
highlighted.
my lord, one more thing. That is
It is a section which defines.
yes, that came across my mind. Actually,
Yes, yes.
although this is not my case, they will argue.
On the
I am there.
MSME, my lord, what my learned senior
No,
friend
no,
has
no.
submitted.
MSME has
that
also
is-
been considered subsequently by
that is
So
Justice
subject,
Datta's.
my lord,
And that is also not been decided. This matter was appealed before the division bench, my lord. There,
but I was there for Union of India,
left
I know.
open.
I was there
It
for
has
Union
not
of
been
India.
decided whether it is applicable
I
to
was for
NBFCs or not.
Ministry of Finance, I was there in the matter. Subsequently, that was settled. But Justice Krishna Rao's order through it. That is there.
So
One.
this point
And
is
second
still,
thing is,
not
my
decided.
lord, see, my contractual agreement that came across my contractual agreement is with the NBFC or bank. Subsequently, ARC came. Will that contract will given a complete go by? Question remains. But
Will
just it
consider
came across my mind that my contract is with the principal lender. Now, subsequently, that lender goes and this
No,
ARC take
your contract with the principal vendor was only for repayment of the credit facilities. Your contract will not command the right which the creditor will have. If the creditor, suppose, becomes a nationalized bank, will you be able to bank on your contract? Suppose this is a possible situation.
this is the question that needs to be
That is
decided.
why it is your contract
Whether
will
it
not
can be given a retrospective
your contract will
effect or
not your contract will not determine the nature of power and the authority which the creditor will have if the statute gives it the right. Because what happens, the loan is assigned, the contract is assigned. The contract was that on such and such terms he will pay. The contract does not command the power. It does not control the power which the creditor has.
My lord will look into it certainly. These
My
are
lord.
the questions just because can it
We
be
will-
given
we
a
will
retrospective?
decide it. We will decide it.
Retrospective because prior to that, when we were doing matters, it is principally settled that no retrospective effect cannot be given. What it is, it is.
No, that is for a law, not for the contract.
So far
Contract
as
will
the
not
contract,
command the
my lord,
authority.
this will, so far as I am concerned, this will something akin to change of the terms of contract.
No,
which
it will
I
not.
don't think it's
It will not. The contract terms do not dictate in what manner loan will be recovered. The contract terms do not override SURFACE. In your contract with the bank also.
Certainly it
suppose-
carries a clause.
No.
That
In
case
your
of default,
Mr. Mishra, prior to 2002, the loans which were entered into SURFACE Act was not even born.
no, not.
So therefore, there was no contract which would have envisaged any provision as regards SURFACE Act. Can you say that because of the contract, the bank will not be able to invoke SURFACE Act?
No, I will be waiting for this, my lord. Out-
My lord.
My lord,
It's not a mere case of
I'm
assignment.
I'm not anything
Securities
else.
companies are recognized under SURFACE Act. It's a separate
This
institution.
My lord.
Personally, I will be waiting for the outcome of this case, my lord.
My lord, and-
Very interesting point of law that is.
My lord, one more indulgence, my lord. If they are directed to produce a deed of assignment, my
Not
lord.
required.
My lord, because I am also guided by a
Not at all,
maxim,
not
my
at all.
lord. Nemo
Not at
that
all,
quod
it's-
not
It's
habet,
only
my
on
lord.
the notification, and I'll deal with this aspect also. Whatever
Great,
deed of
great.
assignment is immaterial. It's
Well,
statutory.
My lord, because the ARC can also act as an agent or the
Anyway,
manager of the NBFC, my
It's
lord.
just statutory. Just statutory.
I'm grateful, your lord.
7, my lord, I'm appearing for the petitioner's service upon the bank, my lord, has not yet completed. If my lord
Your matter.
is, my lord, challenging a sale notice.
Tell why have you come here? Go before the DRT.
No. I tell your lordship what has happened. The loan amount was
Whatever
very
has
small.
happened, it's an action under
amounting
13
to be 9 lakhs. Out of that, 3 lakhs has been paid, my lord. Give me some protection, my lord. It is 11th August is the date fixed for. Keeps it tomorrow, my lord. Let the bank come, my lord.
You can, the bank will say this, and the moment the bank says
The
this, I will
account
not
has been
entertain.
declared as NPA, my lord. What has happened?
Whatever you have to pay, you pay. and
Thereafter, they have accepted the payment.
There is no bar in accepting payment after.
No,
the-
I'm not
having the
standing
document.
that way, my lord. Let the bank come, my lord. Keeps it
What
tomorrow.
will be the use? What will be the use of keeping it tomorrow unnecessarily?
Let the bank come, my lord.
What
For
will happen
satisfaction,
if the bank comes?
once, let the bank come. If they will,
You can prevail over the bank and get your dues
No,
settled.
I'm not-
It's all
I'm not
fine.
standing that way, my lord. Let the bank
Because
come.
this matter unnecessarily, why will it remain pending? What is
Tomorrow,
the
my lord.
use?
Keeps it tomorrow. I shall
Not today.
at the same position, my lord.
Not
Because
today.
sale notice will be date of auction, my lord, will be on this 11th August. Before
You are-
that,
you
some
are-
protection.
You are unnecessarily
already
delaying your
paid.
matter. You could have gone to DRT.
I completely appreciate, my lord. Whatever
We are
fallen from my lord,
I'm telling
completely
you,
bow down.
putting you on notice, this will end in dismissal ultimately. You should have
Come,
taken
my lord.
steps. If you are prudent enough, get it done now, or tomorrow the same fate will follow. Next.
My lord, I have applied.
My lord, I am for the respondent number 4 in item number 8. My lord, I had used an affidavit in opposition, but I have served on the petitioner. May I be permitted to formally file it? Court?
For the petitioner.
Yes, your lordship, we will need 2 weeks time to file a reply of the opposition.
But,
The petitioner is
no copy of the if I can get a copy of the opposition.
Very well. I'll serve upon.
Also,
I'll take that.
I am for the respondent number 1. I am not getting any
My
copy
lord,
of the
my lord, basically the conspectus of the matter is, my lord, I had approached the, my lord, ombudsman for, my lord, a dispute between myself and my brother. Common building, my lord, I had a separate meter in the ground floor. But, my lord, what happened was during COVID, excessive billing was made, disconnection was done, permanent disconnection was done. I applied to the station manager. Thereafter, things escalated to the ombudsman. My brother and myself, we fought. And ultimately, the ombudsman gave an order in my favor, saying that the ground floor portion be given a separate electricity connection in favor of the respondent number 4. From this order, this appeal has been preferred, alleging that there are several irregularities in that. But I do not know, my lord, if there has to be any opposition from the ombudsman itself. From my opposition. There cannot be any opposition to the order because
doesn't-
I am in favor of
He
the order.
doesn't want to use an opposition.
he wants a copy.
You want to use an opposition to the writ petition or that? He is an adjudicate
I will just
authority.
serve him formally. That's all.
Whatever.
I am just WBSCL also nothing to say.
Affidavit in opposition filed on behalf of the respondent number 4 is taken on record. Full stop. Learned advocate appearing for the petitioner seeks time to file affidavit in reply to the affidavit in opposition that has been served upon him today.
My lord,
My lord, petitioner, my lord, prayed for a compensation due to the death of her son, my lord, by electrocution. My lord, on earlier occasion, the petitioner came before this honorable court, and this honorable court has passed an order, my lord, which is at page
23.
my lord.
Page 23.
Page 23, my lord.
Yes.
The relevant part of the order is, my lord, paragraph number, my lord, 3. The writ petition is disposed of without any opinion of the correctness of the contentions of the petitioner. The writ petition shall be treated as representation of the petitioner and disposed of by the concerned authority in accordance with law. The petitioner and the representative of the Kagdi Customer Care Center, South 24 Parganas, shall also be heard at the time of disposal of the writ petition. Reasoned order shall be passed and communicated to the petitioner. The entire exercise should be completed
Who
within a
is the
period.
representative of the customer care center?
My lord,
Supposed to be the representative of the customer care center.
A representative of the customer care center is the station manager.
So station manager is supposed to be the representative. He has passed the order.
yes, that is my point. My lord, the reasoned order has
On
been
the last
passed.
day, yesterday, I have brought to your notice of your lordship.
Listen.
It should be Zonal Manager, Kolkata.
or is representative, Lordship. My similar type of order has been
This
passed.
petition assails an order dated
এটা রেফার করেননি রেফার করেন
I am appearing for distribution company lordship. Connection was effected on 7th May 2026. Yesterday petitioner was present. Francis is redressed. This matter.
Yes, sir.
This matter appeared yesterday.
Yes, 7/5/2026.
It's very agreeable.
In the lower portion, lordship, in the bold letters,
Both the petitioner as well as the learned advocate
At number 11, my lord, the petitioners applied for the new connection for the residential purposes, but till now,
not given.
yes, we have
sure.
already
Okay.
supplied all the documents.
We have no difficulty. My lord, we have made attempt twice. First time, I was prevented by the private respondent. Second time, after 1 year, my lord, again, a notice was given for inspection. That time, the same private respondent citing the pendency of a civil litigation. My lord, we are restrained. My lord, we have no difficulty. If my lord, otherwise, my lord, we are protected, my lord, we can provide connection.
My lord, for the dispute of the title, the petitioners have been suffered.
It was delivered. They have not appeared. Affidavit of service filed in court today is taken on record. But
Yes, my lord. My lord, since that was getting delayed, my lord, the petitioner himself visited the office of the concerned respondent. My lord, therefrom it was stated, my lord, to give a GPS or GPRS location of the residential house of the petitioner. That has been submitted on 30th July, my lord.
One more time.
My lord. My lord, this is the document that I have submitted before the authority. I'm giving a copy to my learned.
Yes, but you then file it by way of a supplement.
My lord, I'll supply.
And you give it to the authorities also.
I've given a copy and I'll come up with a supplementary affidavit.
As prayed for, comma, leave is granted to the petitioner to file a supplementary affidavit.
And I am the petition. And my learned friend, they also paid for accommodation for this.
लिखे नहीं an accommodation is paid for on behalf of the respondent bank authorities. Full stop. List this matter after a week.
My lord.
1 week.
Yes.
Next.
I am for the respondent number 6.
Sir, I appear at behalf of the CS.
Lordship, kindly seize the last order once.
17th of July, if I am not wrong.
Yes.
Lordship, respondent number 6 has carried out his what, Lordship?
I make these
Completed.
representations to the CSC, your Lordship. Without the CSC supervisions, I cannot relocate the where's your Lordship.
Please take the mic.
Lordships, I made after the order has been passed, I made these representations to the CSC on 17 July 2026. For that, I am ready to cooperate, your Lordships, but the CSC didn't approach.
We could not, Manoj. There is a specific order, Manoj, and it is in respect of the internal wiring.
What will CSC do? It is for you to revamp your wiring.
Your Lordships, without the CSC supervisions, we can.
CSC will not enter into your house to supervise. That is not their job.
That is the all the wires are
Their
in the
business
collapsible
ends, their
gate, your
business
Lordships.
ends at the point of commencement of supply, where the meter is installed and the wires come out for the purpose of getting joined with the main meter. Their business ends there. After that, it is your outlook. You cannot call
Your
the
Lordships, it's not in the inside, it's the outside. It's in the collapsible gate, your Lordships. All of these are hanging.
after the meter.
Yes, Lordship.
Can be after the meter. After the meter is the cutout. If there is anything beyond meter within your domain, CSC is not there, then I will direct disconnection. Then you are playing.
Just have ready to go, but I also already
no
made
question
this.
of cooperating. You call your electrical contractor, get it revamped. There was a specific direction on the last occasion also. You had not represented. Someone else was there. Where is he? I had directed that I will direct disconnection then. I will direct your client to be disconnected.
Your Lordships, I already have the bona fide, your Lordships. I made this
There is danger of
representations.
fire. There is danger of fire. You are not revamping the wires. You were earlier on earlier occasions. You had saddled the other side with the liability, saying that he is not doing his part of job. Now he has done it. Now the fault is absolutely yours.
Your Lordships, I made this
You have been shifting
representations
the
to
blame.
the CSC for the
Don't play drugs
cooperative,
and
your
debts.
Lordships.
No.
Without the CSC supervisions, it will be very difficult to relocate that.
CSC is not going to supervise, madam. Your internal wiring, if you call the electricity utility, how will they take care of the public purpose? That is your purpose. Merely because you have come to court, therefore the court will have to direct the electricity utility to fix your internal wirings. That is not their job. You have to get it done according to your suitability. Take up electrician Call for electrical contractor, get it done at your own costs. CSC will not come in the picture.
The third round of litigation, and earlier manner, we also find a report manner which might not.
I will now direct disconnection because there was specific stern warning in the last order. I will stick to my order. I will ask your line to be disconnected. The moment it is disconnected, he will get all assistance and he will get
Your
it done.
Lordships, kindly allow me,
Very
Your
well, then
Lordships,
get it.
I will.
I'm directing it disconnected. I'll check
Lordships,
this to be
kindly.
listed after next year.
Your Lordships, I will do the accordingly. I will tell my client, Your Lordships, to follow this order and to
I'm
do
directing
it.
this matter to be listed in 2027 and I will direct disconnection.
Your Lordships, kindly, Your Lordships, kindly allow me, Your
Then why
Lordships,
are you
I will
reading the order? This
do it
14th
privately,
of
Your
July
Lordships.
2027 order, clearly kindly read the order. Come to the order.
Yes, Your Lordships. I have gone through.
Kindly read paragraph 7.
Your Lordships. Kindly allow me, Your Lordships. I have already informed him. I will inform him, Your Lordships.
No, but it doesn't seem so. You are now taking a different stand altogether. Earlier, your stand was that they are not cooperating. It was never your stand that I want CSC to be there. Even if it was your stand, I would have negated that on the first day itself. Because if it is some internal problem, your internal wiring, you cannot expect the electricity utility to come and fix your job. It's your domestic problem. They have a duty till the point of commencement of supply. Beyond that, they don't have. Yes, if there was fault with the cutout, fault in the cable, which is leading to your house, they are responsible. They will have to do it because you don't have authority there. Where their authority starts, your ends. And where your authority starts, their ends. So there is a separate compartment.
Your Lordships, kindly allow me, Your Lordships.
But I will have to go by my order. I will have to
Your
disconnect.
Lordships, kindly keep this order. I inform him, Your Lordships.
Ask your client to be fair. This unfairness thing, I will immediately disconnect and list it after 1 year.
Your Lordships,
It will not be
kindly
reconnected
allow
for
me,
1
Your
year.
Lordships. Kindly. I will.
लिखे नहीं. Learned advocate appearing for the petitioner seeks time to
Point is very limited, my lord. Unauthorizedly, electric pole has been erected in my land. My lord will kindly take up. There is two portion of land. One has been 15. One has been purchased by me, and another, well, the government of West Bengal has granted me lease. But if your lordship kindly take up page number 15, all the title deed start from here. Thereafter, my lord, straight away.
Page 15, 1-5.
Yes, my lord. All the title deeds. Thereafter, my lord, at page 35, the ROR in my name, my lord. This portion has been purchased by me, my lord. If my lord will kindly take up thereafter at page number 37. Some portion has been granted lease by the government of West Bengal to me. The purpose has been stated there in my lord. All the payment receipt are there at start from page number 40, annexure 3. Thereafter, all the payment receipt subsequently I have paid. Last payment was made on page
These
number.
are documents of your ownership.
Yes, these are the documents of the ownership. But what has happened, my lord? Thereafter, the respondent has erected unauthorizedly erected some electric poles at my land, my lord, which create difficulties to me, my lord. But I have made representation at page number 50. Two representation has been made on 16th/10/2025. Thereafter, my lord, on 29th/10/2025. No steps has been taken, my lord, in terms of my representation. And if my lord will kindly take up the photographs at the last, at page number 60, how they have erected the poles in my land. It's highly dangerous for me, my lord, and the person who are residing, or the for the purpose. This is my all the contention, my lord, with my kindly direct for removal of the unauthorized electric poles.
Yes, Mr. Shah, Dr. Sara, how did you install erect poles in his land?
So far, Lordship, I have taken instruction on this issue, that how this pole can be installed in a particular owner's land. It has been specified, this pole has been installed 20 years back, and it has not been installed in their land. It has been installed beside PWD road and the village pathway. Again, further inspection has been taken place since this petition has been taken away. And on that inspection, it has been specified that it is not been installed in their land. Now, on this pole installed 20 years back, and they have made a representation on 16
When
10
did you purchase the land?
My lord, I have purchased the
16
land in the year of 2010.
So if it
Before
is 20
that, my lord,
years, if it is
before that,
20
I tell you, lordship, about the sale deed. It
if
has
it is
been
20 years back, then in that
Oh,
case,
my
it
lord,
was
it has
prior
been
to your
erected so
purchase.
far to my instruction, my lord. It has been erected last year, my lord. No, if your lordship kindly take up the photographs, it's showing.
Photographs, how will I, from the photograph, how will I come to know about
Let
the
the
year of
inspection be carried out at my presence, my
inspection?
lord.
Also, how will the inspection reveal the age of the pole?
In 2010, my lord, Government of West Bengal granted me the lease. It's appearing from the
Case.
documents.
So if his case is,
Thereafter, my lord, I have
his case is that the pole was installed 20 years back, then it takes us to 2006.
Yes.
If you got ownership of the property in 2010, you purchased it with the pole.
No, my lord, that is not my instruction. It has been erected
To you,
after
when was-
purchase of
according
my
to
land.
you, show me when was the pole erected according to you? Where is the averment that it was erected, and why did you not raise objection?
My lord, kindly take up my representation.
Representation will not do. Show me from the writ petition when the pole was erected.
My
Then
lord.
you will take me to representation.
In paragraph number 6, I have mentioned in my writ
Yes,
petition.
but it does not show when.
Let me take instruction, my lord.
It will
With
not
the
serve any
documents.
purpose. You make a representation before the district magistrate.
Yes.
District magistrate is the authority to decide objections as regards installation of pole prior to the pole being installed if you have raised objection. Now, there is nothing on record to show that prior to installation you raised objection. So now, in terms of this rule 3 of the workshop licensees rules,
My lord.
you approach the district magistrate with a representation. He will dispose of the
Grant me the leave, my lord. I shall file a representation before the district magistrate. But kindly record my submission, my lord, so that I have the instruction, my lord, after
Make a
purchasing
representation
of the land.
there. This is not there.
But kindly record
The
it.
matter is to be
What?
heard in presence of DLNRO and the concerned authority.
That the district magistrate will decide.
Lordship, Lordship.
Affidavit of service filed in court today is taken on record. Full stop. The
I am for the petition. Your lordships heard this matter earlier, my lord, and directed my learned friend to, my lord, submit a report. They have submitted a report, my lord. I have found from the report that after 2020, the final assessment bill only on 27th of October 2021, they raised a bill, but this bill I have not received. And, my lord, the present situation is this, my lord, in the present bill, my lord, they have, my lord, quoted a outstanding amount of rupees 1,33,000. My lord, in terms of the High Court's order, while I am, my lord, preferring an application for anticipatory bail, this Honorable High Court with the division bench directed me to deposit 60,000 and to pay on, my lord, the current outstanding bill. My lord, since then, my lord, I am regularly paying the current outstanding bill. So the last bill, which has been raised by the electricity distribution company, they have first time, my lord, raised this, my lord, outstanding bill, and they are not accepting my current consumptions bill, my lord. My lord, I am under apprehension that if I not paid the entire bill, they will disconnect my connection. But even then, for abundant cautions, my lord,
There was an allegation of theft and a final order of assessment.
final
was
assessment
passed.
order was passed after the my lord.
Final order of assessment has been challenged.
No, my lord, no appeal has been preferred at the BS.
That has attained finality.
Attained finality, my lord.
You have to pay that off.
My lord, what is, my lord, my point is this, my lord. My lord, if your lordship kindly takes pen to the 56(2), my lord. My lord, in
56(2) will not apply to theft.
my lord,
56(2) is for regular billing.
my lord, any other sum due, my lord. It has
Any
been
other sum due for non-payment
My
of
lord,
consumption.
but
bill.
even if, my lord,
Well settled.
my
Well
lord,
settled.
my lord, even if, my lord, I wrote a representation before the authority, my lord, I am ready and willing to pay that amount. It's not that, my lord, I will not pay. But
You have allowed the final order of assessment to attain finality, you have to pay.
my lord, if my lord, some I am asking for, my lord, some installment, my lord, so that I can pay, my lord.
I cannot mandate that installment under what
Well,
law?
let them accept my current consumption bill for this month, since they have accepted last 5 years.
You are free to approach them with your request for installment. They will be free to grant you or not to grant you. I am nobody to tell
But
them.
till such
you
time, no
accept
discussion.
this.
But till such time, well, in that event, there will be no use of.
You should have paid then.
Well,
Why did you not pay?
But I am a poor cultivator, my lord, within a week, my lord, 1,30,000. Kindly consider they have not raised bill last 5 years, my lord.
Either you speak or allow the court to finish.
My lord, kindly.
Then why did you commit theft of electricity? Poor
My lord,
cultivator should not have
my lord,
committed theft of electricity.
my lord, that is a subject matter of trial, my lord. My lord, kindly consider.
Subject matter trial is only criminal intent.
Yes, my lord.
Civil liability remains.
Well, that is why, my lord, I am saying, 56
Civil
to, my lord.
liability remains. Merely because you will get acquittal over there, therefore a civil
But
liability will
that, I have to pay, but that is the standing law, my lord. It's true, my lord.
And then
But even if, my lord,
don't
acquittal,
argue that.
my lord, so far the theft is concerned, if the theft go, my lord.
Theft goes, unauthorized electricity,
My lord,
unauthorized consumption.
now I am
remains.
ready and willing to.
You may not have done it with the intention of stealing, but you have unauthorized the abstracted
But,
electricity
my
under
lord,
126.
my
What
lord,
will happen there?
my lord, what has happened, my lord, before the
135, you will get scot free. 126?
my lord, before the division bench, my lord, while we prep,
That is for bail. That is condition of bail. Division bench.
my lord, if your lordship kindly takes pen once, my lord, the order, my lord. My lord, that's why, my lord, there.
Anticipatory bail order will not set
My
aside
lord,
the final order of assessment.
No, my lord, that's not, my lord, but the observation given by the division
The
bench.
observation was, because of that, he will not be arrested. The observation cannot be stretched to mean that you are absolved of making.
That is not. That's why, my lord, the department itself also did not raise bill, my lord, last 5 years, my lord. Suddenly, 2026, in my current bill, they have, my lord, added the outstanding bill, my lord.
Judgments, this 56(2) will not apply. If that is your case, I can keep it tomorrow, give you the.
My lord,
yes, there is
I know it.
division bench of
But-
this court, several high courts, and several single benches.
My lord, only, my lord, I am praying, my lord, mercy, this honorable court, my lord, kindly allow my learned friend to, my lord,
I
pay,
cannot
my lord,
direct them.
my lord,
You
only
can-
that request, my lord.
Mr. Bhattacharya,
My lord, I will approach, my lord. Certainly, I will approach. My lord, already I have approached. It's not that already I have approached. They have not decided as of date, my lord. I have already approached.
They will decide that. They will decide that.
That order
is the best that I can do.
But till such time, my lord, kindly give some protection, my lord. Last 5 years, my lord, they have, my lord, I have paid the current outstanding bill, my lord.
If for last 5 years they have not done, you are rest assured that they will not do it now also.
That, since, my lord, in this present bill, my lord, they have
Why
so.
don't you prevail on Mr. Bandopadhyay? He is more influential.
Well, it can be viewed in a different way. Well, for last 5 years, he is sitting tight. He has not paid a
You are
penny.
also sitting tight.
He has
You
been
cannot-
continuing with the
You are
current
also sitting
consumption
tight.
fee. We have been accepting.
Last 5 years, the authority also sitting tight.
A report in the form of affidavit filed on behalf of the respondent, WBSCDCL authorities is taken on record.
Grateful, Your Lordship.
My lord, I appeal for the respondent bank.
17.
That's
I appear on behalf of the petitioner. This is OTS matter.
Oh, yes.
My lord, I have taken instructions from the bank, your lordship. My lord, the instruction says that they have adjusted the amount of 11 lakhs 20,000. After that, they have agreed to the proposal of 86 lakhs. Otherwise, it would have gone up to 97, my lord.
Then there is no case of refund.
Lordship.
My lord, all these things were never made clear to us.
What to do? Then I will have to call for affidavits and it will be decided on affidavits.
And this refund issue, my lord, is also pending before the recovery officer, your
And
lordship.
my lord, my second point that I have paid extra amount of 30
You
lakh
haven't paid
again.
because they say that the offer was accepted after this 1120 having
yes.
been appropriated.
Yes, ma'am.
Then let them file their
My
affidavit.
lord, kindly have it decided by way of affidavit.
Lordship.
They take a decision, this will go. Yes.
Because my lord, in all the forums, they have maintained the same stance that the amount of 11.20 lakhs ought to be refunded. And now they are making this submission that
They
is
say what they say on affidavit.
Great.
My lord, I am for the petitioner. The petitioner is the president of Lord Chaitanya Gauriya Shivashram, which is in Gangasagar.
Kindly see your lordship last order.
My lord, last order, your lordship, can see. On that day, below the petitioner's advocate are not present. The respondent number 6, my lord, they have encroached my land. And my lord, they applied for the electric meter. The station manager, without giving any opportunity of hearing, my lord, they allowed the connections. For that reason, my lord, I have come before lordship. Previously, it was not there, my lord. But during the pendency of the case, my lord, they have given connections. My lord, your lordship, kindly see the owner, my lord, your lordship, kindly see the page, my lord, 15, annexure P2. Here clearly the page 15, annexure P2. 15. And chairman, he is the chairman of the Development Authority, my lord. He has given the no objection certificate. Your lordship, can you see? Chaitanya Gauriya Shivashram, plot number is there. And my lord, the respondent number 6 is a Shebait of Lake Kalivari, my lord. He encroached the land and applied for electric meter. It is a Chaitanya, it is a land for the Chaitanya Shivashram. And my lord, they have encroached the land and applied for the electric meter. And immediately, my lord, I made a complaint, my lord. Your lordship, can see the complaint, my lord. That is the page, my lord. Page P5, annexure P5, page 22. Station manager. Without giving any opportunity of hearing, they have allowed the electric connection to the respondent number 6, though he has no right interest of this on the said plot of land.
But he is in possession of the plot of land.
I am the possession of the plot of land. They have encroached my land.
Even if he has encroached and he is in possession.
So, my lord, your lordship, can you see the annexure P2, my lord, here? Annexure P2 here clearly stated, my lord, they have no objections, my lord, if I, your lordship, P2, it is a chairman given this no objection certificate.
This no objection certificate is
chairman. Following plot is under the GDP Gangasagar. So I have the consent to give their land for the AL and LR department. I have no acquisitions against them. I therefore appeal to you to do the needful step. He wrote the letter to BL and LRO. So, my lord, when I taken the position, I am in the positions, my lord, the Shivashram, my lord, the respondent number 6, who is a Shebait of Lake Kalivali, my lord, she encroached the land and applied for electric meter.
But how will the writ court decide this encroachment or not? These are all.
Station manager have come against the order of this electricity because my lord, I wrote a letter to the station manager, please you decide the same. Your lordship can page annexure P5.
Even
They have
station
not given
manager,
any.
what will he decide? Station manager will take inspection. If he finds that a person is in possession, he will give electricity supply in terms of.
And my lord,
43.
let them say he is an owner of the land, or my lord, he is in a positions.
Owner of the land is not.
No, but my lord, here in position.
Yes, occupation if he's in,
Yes.
because 43 says
But
two things,
without-
either owner or occupier.
And my lord, they are not even occupier. So my lord,
If you
Respond
say that
number
he has
6.
encroached, he is in occupation.
respondent number 6 is not occupier. I am the occupier.
You said that he has encroached. If he has
Encroached.
encroached, he is in occupation.
Yes, he encroaches not, he's encroached my land. If he is by force, my lord, no.
What your lordship is inquiring is that paragraph 9 of the writ petition.
If he is in possession, if he is in settled possession of something, may be illegal. But till such time that you evict him, he will be entitled to electricity
So my lord,
supply.
they have applied for electric connection similar with the station manager.
That will not create any equity in their favor because of the electricity.
Right.
That will not
But
be-
my lord, they can, the station manager, my lord, without seeing any documents, my lord, they give electric
Yes,
connection.
what documents you saw?
My document, my lord, we went there, we found possession, kindly see.
No, but your online application requires a lot of documents.
Now, my lord, kindly see once. But what my learned senior friend is showing to your lordship, page 15. But this is nothing but a letter by the, I should not say, my lord, one of the MLA come chairman.
Chairman.
Thereafter, there is a dispute pending before the West Bengal Land Reforms and Tenancy Tribunal. Kindly see the page 16. We don't know anything, my lord. Now, my lord, their dispute is pending. Now, my lord, whether it is his land or not, we went there, we found there is a
land and title. You
we can't decide. We can't do. We found.
You are not concerned with, but so far as the documents are concerned, what you have to see the documents with the.
But in the
online application
in
form,
the
there are
in the
several
online
documents.
application, your lordship knows better than me that in the online application he applied for connection, showing that he is in possession. That is,
he has to give Aadhaar card or something. There are certain 4 or 5 documents which are enlisted there.
I
Which
will-
documents did you see?
then my lord, I will.
That has to be If you don't show compliance with the
No,
and you have allowed
what
electricity, then that's right.
what we are doing, your lordship knows better than us. That my lord, when someone is applying in the online, my lord, automatic generated, my lord, bill has to be sent.
That's right, but you will.
I'm
see the
telling you, lordship,
compliance.
when you went there, we found if we went there, suppose today, something fraud has been done, no document has been filed. Now, my lord, we went there, we found.
I'll do this.
My private respondent, he applied, he can show before your lordship what document.
I will not see that. The station manager will hear both of you.
Yes.
You produce your documents.
Yes.
If
They produce their document.
Of course, if he is able to satisfy that he falls within the documents which are required online with the application form, then in that case the station manager will continue with the electricity supply. Otherwise, he will disconnect.
Yes.
He has to satisfy.
Objection. Yes.
Compliances were met.
But may I say this, my lord? Number 1 is, my lord, the document that my learned friend is showing, which is page 15, is no document, my lord.
I am not on that at all. Since he has come up, he says that there is a case of encroachment. I am not on that also.
Right.
But so far as your right to get electricity connection is concerned, the online application is to be accompanied by a list of documents.
Right.
Now, those documents you have to satisfy that those were there.
No, the government has given me lease.
If the station manager is satisfied, well and good. I am just sending this representation back to the station manager to consider. He will give an opportunity of hearing to both of you.
Yes.
And he will take a decision on this.
Yes. Yes.
But 2 things. First is, my lord, in paragraph 9 of the writ petition, he admits that I am in possession. Please have a look at paragraph 9.
Yes.
This is the admitted case. My lord, if this is the admitted case, I am in possession. My lord, your lordships have always held that so far electricity is concerned, the electricity authority will only see whether the person who has applied is in settled possession or not. He may be a trespasser also. Number 1. Therefore, my lord, on this admitted case, my lord, whether, my lord, your lordship would relegate it back to the authorities or not, my lord, I leave it to the court, to the wisdom of the court. But ordinarily, my lord, since this is the admitted case, my lord, it should not go back. Number 1. Number 2 is, my lord, the document that my learned friend is showing my lord, in my very respectful submission, do not, my lord, inspire at least legal confidence. Why I say this? Because, my lord, the government land, my lord, cannot be distributed in this way. My lord, some MLA, some MP saying that I have no objection if the High Court is sold to Mr. Kishore Datto, that will not create any right in favor of Kishore Datto. Therefore, my lord, the policy or, my lord, the laid down norms are that, my lord, it is an interdepartmental decision that has to be taken. For example, my lord, all the repository of, my lord, all government lands is, my lord, the Land and Land Reforms Department. Now, if Fisheries Department requires some land, then, my lord, fisheries have to apply to the Land Department. Then Land Department will allot it. And there is a long, my lord, procedure. And if somebody wants to, my lord, have it, my lord, on long-term basis, that person is going to apply before the concerned department, and then, my lord, through cabinet and all that, my lord, this is allotted. But in our case, this has happened. Through, my lord, a cabinet memo, through cabinet approval, my lord, this land, my lord, has been allotted, and subsequently, my lord, a registered deed of lease has been executed. My lord, please have a look to the, just kindly have a look at it. Whether only for, my lord, your lordship's consideration, whether at all, my lord, this exercise should be undertaken at the instance of a person who has no document to support his case. Well, kindly take me the first document, my lord, at page 1. But this is an inspection report, but somewhat, my lord, illegible. Now, please take, my lord, the government body is no objection at page 3. Gangasagor Bokhali Development Authority. But this is page 3. Then the proposal of the government is, my lord, the next page, which is, my lord, page number 4. Kindly take me the first paragraph. Towards the last, my lord, last 4 lines of the first paragraph, construction of Jatri Nivas, running community kitchen and medical camp during Sagor Mela for the pilgrims, and also for erecting sculptures of eminent artists of Lord Shiva and Mother Ganga in resemblance with the culture and tradition of Gangasagor Island. Now, now the proposal goes, now cabinet approval. Please, your lordship may kindly take me the next page. There, my lord, your lordship will find the cabinet approval, paragraph number 7 of the same document. My lord has found that, my lord?
Yes.
Paragraph 7 at page 5. This is cabinet approval. Then, my lord, official possession is given in 2021, page 6. But the government gives me possession. And my learned friend is showing that somebody is no objection. Then kindly have a look to me at the lease deed. My lord, paragraph number, page number 9. Registered lease deed, my lord, executed between the governor and, my lord, my client. Page number 9, my lord, your lordship found. Then record of rights have already
Let my
been
learned friend
collected.
produce the entire document.
No,
before
why
the station
at his
manager.
instance? Why at his instance?
But I have not seen.
No, you are not entitled to
see
see anything and everything.
Useless exercise.
Yes. Now, please take my paragraph,
They
page
will,
number
my lord,
39.
he will affirm the if in oppositions or, my lord, the documents, annex the documents.
But the record of rights have been corrected, page 39.
I will verify when the connection has already been given. My lord, opposition may be given. My lord, they can file any opposition.
What is the use of opposition, sir?
Yes, page number 39, my lord, রায়তের নাম পশ্চিমবঙ্গ সরকারের পক্ষে কালেক্ট।
Then I can give a reply.
লেসির নাম শ্রী শ্রী 108 করুণাময়ী কালীমাতা মন্দির, লেক কালীবাড়ি। Then, my lord, tax payment. Everything is done. Page number 41.
See, the page 49
Yes,
is what the exercise is done.
Yes. Application for electricity.
Yes, kindly see the enclosures. You have the land ownership or property document, tax receipt, panchayat, municipal.
Yes, everything.
So they have it.
My lord, one thing, my lord, they also given the authority also given the same sanction. My lord, what has happened, my lord?
You don't have a lease deed in your favor. And
My lord, let
according to you
my
also,
learned friend file the affidavit by stating
what
this
is the
fact.
use? Unnecessarily it will be prolonged. There is no use.
my lord, then my lord,
Very well, you file your affidavit. It will be unnecessarily. It will be pending.
and my lord, I will take instructions.
Uh, let affidavit in opposition to this writ petition be filed within
Give us 2-3 weeks.
2 weeks from date.
And I will
Affidavit
take
be
one
there
week,
to
one
be
week time,
within
my lord.
1 week thereafter. List this matter 3 weeks hence.
I'm deeply obliged.
I'm grateful.
There is no use actually.
The other side is here, my lord. Can it be taken up now?
There is a fixed matter after that. Yes, Mr. Bhattacharya.
My lord has already heard it, my lord.
You have seen the earlier application. There are a lot of lions in the way. Look at look at the second paragraph.
Yes.
Read it to yourself. Read it to yourself. Especially second page. They were all late. They were all late. And then they suddenly become alive.
My lord, I have taken instruction, my lord. This was, my lord, filed, my lord, RAT, my lord, since the execution was proceeding, my lord, in terms of your lordship's order, my lord.
And
This was
they all seek to be implemented as co-petitioners, co-applicants. Now, Order 1 Rule 10(3), it will be, he is seeking to be added as a plaintiff in a sense.
Yes.
So it cannot be without his consent. Now he withdraws this consent with this application. Can he re-give the consent? That again is an issue. It's a problematic thing. It is not that easy.
No, my lord, two things, my lord. First, my lord, the 2199-101, my lord, it's not is, my lord, it is a nature of a claim. Now, my lord, it is, my lord, the plaintiff or the applicants in the mis case, they are the dominus litis. It's not the, it is not that they are not being added in the category of the opposite party or defendant. Therefore, whether
that is why the stress.
Therefore,
test
what
becomes
is
more
the, my lord,
stringent.
right, to what extent the opposite parties have right to challenge that, my lord, that is also doubtful.
No, before the opposite party is right, it has to be shown that you have the right to maintain the second application for being added upon having withdrawn it.
That is between me and the court. Court has exercised its jurisdiction. I say that
Whether the
opposite
court-
party has no right to challenge it.
Opposite party has right to challenge
Because I am the locus standi. I
No.
have not disturbed his right.
It is not like that an independent suit, Mr. Bhattacharya, because this is a case where by this application you are not as if maintaining a suit. You are, by this application you are seeking to
Akin to a suit.
interdict his decree.
Akin to a suit.
Akin to a suit, but akin to a suit not in the sense, because in suits there is no right crystallized in favor of any party till such time that a decree takes place. Here it is a suit which seeks interdiction of a decree. So therefore
that is the statutory provision.
tests- Yes, but the tests are different. Therefore, that is why you cannot apply it in that fashion here.
That will be decided at the trial. I am on whether the opposite party can at all challenge it.
Even if the opposite party cannot challenge it,
It
the
is
opposite party
then, my lord, it is between the petitioner and the court.
has a right to challenge the order.
No,
He has a right to
not
challenge
this order.
Exam.
Not this order.
Definitely he has.
Not this order.
affects
Because
him.
I am
Why not?
the dominus litis. I want
Also,
anyone
he is
to apply.
He
I
is also
will
the
apply.
dominus litis of his application.
And
for
not that
execution.
too, not in the
Mr. Bhattacharya,
category of the
he is
opposite
also-
party.
He is also the dominus litis of his application for execution, which you are seeking to interdict.
Yes,
Yes,
there is
so-
no addition of party.
Yeah, of course, it is in that course only.
The addition of party in the mis case, not the
Very
execution.
well. The mis case is arising out of the execution
That is there,
application
that is
only.
there, that is there.
It does not have an independent status like a suit. It is not a TS.
That is
Then it is,
But
that is
two
why I
things,
said
my
that
lord.
the same
One,
standard.
my lord, another, my lord, this is what, my lord, I cannot improve upon facts on a point of law, my lord. 23(3)(a), my lord, 3, my lord, it specifically says applies to a suit.
Yes,
Not the interlocutory
I never
proceeding.
said, even on the last occasion, I said at the very threshold that it is not akin to 23(1) or 23(3). It is by reason of public policy. Because look at what you are doing. You come to court, file an application, withdraw it without leave to file afresh, you file another. Suppose this happens 3 or 4 times, the court still retains Order 1 Rule 10. The court should be allowed to exercise this power. That is not fair. Because if it can be done once, why could it not be done 100 times? Then the logic which applies for the second repetition, why should the same logic not apply for the 100th repetition? Then in that case, there has to be a line. The line is therefore when you seek to withdraw without leave to afresh, that is the end of the matter. That has to be treated as having been abandoned. Now, here also in the application, it seems that you were the person who has applied was described as late. He was dead. Now that was sought to be corrected. Now, I don't know when this correction was done. The subsequent application does not contain that averment. So he has I mean been resurrected to life in between without the corrections being done. Have the corrections been done in the application?
No.
Which
Which application?
Second application.
No, in the Order 21 Rule 97 application, they, according to this application, in the Order 21 Rule 97 application, they have been depicted as dead. Now,
what they have done, my lordship, son is telling my father is died. He has filed the GMS case. Now father is coming here. Because in the application under Order 21,
so please try to understand what I am saying. In the application under Order 21,
he has written late.
Yes, that is what I'm saying. It has been written late. Has that late been corrected? That no, he's live.
No, not corrected.
How will he file this application?
That's why Order 1 Rule 10 to add him on the category, on that category, and to delete.
How will he do it in his application unless he files an application for amendment of the Order 21 Rule 97?
That is consequential. I will definitely file.
But he has this application, he is dominus litis then he has to say that yes, it is wrong. Where is that application?
Provided, my lord, he is there in the list. My lord is
not provided he is there in the list. He has chosen to project his father as having died. He has chosen to write his father as late such and such. Now, therefore, it was incumbent on him to come to court and say that this is a mistake on my part. Let this late be deleted and it be replaced by Shri or Mr. or whatever. He has not done that. Now, suddenly from nowhere, someone else comes and says, no, I am his father and I am alive. That is also not the statement. He says there are certain typographical errors. Then this application is withdrawn. The next application which comes does not say anything of this sort. Then what happens to that late?
No, Milord, then Milord, Kalipod, that is independent application of Kalipod.
Then in that case, he cannot be dominus litis. Then that argument fails. And then that argument goes.
That is there. Because Milord, one thing, Milord, he is alive because he has signed, Milord, appeared before the Milord, the stamp of the oath commissioner is there. He has appeared before.
That is neither here nor there.
Yes, it's there. It's on record 130, page 130.
It is neither here nor there because he made the application, he withdrew it. He did not say that I have not made the application. Typical.
This is what, Milord.
Addition or adoption?
Adoption. And there is another application at page 135 by Kalipodo Milord for adoption of the plane.
Yes, that I've seen. That will only be there once he is added as party.
Yes.
Order 1 Rule 10.
Second part.
Yes. Could have come at the first instance.
Yes,
it did not come then. And then knowledge. He says 4-6, the application was filed on 1-6, the earlier one. The moment you cross one hurdle,
Another comes in.
Hydra-headed hurdle.
This is Milord, what is there, Milord? I cannot improve much on
difficult, very difficult.
Milord, one order, Milord.
Order has 3 parts.
Lord, my lord has only minded to interfere with the addition of party part.
Yes.
Lord, the other parts remain. My lord, the impounding part remains.
Impounding part, how can I? Impounding part, they have an the court is bound to impound it. Once an agreement a document is placed, which is required to be stamped and has not been stamped, it is the duty of the court to impound it.
On that,
Your lordship will
Lord, I will be relying upon one judgment.
Your lordship will visualize
1988 documents.
Whatever it is,
No, 1 minute.
Mr. Datto, the impounding will not
was also there in
impounding will not validate the document. It is not on the genuineness. It is only on the question as to whether it has to be.
Yes.
Yes.
I want to submit that the documents which in 1988, which was found in 2025, is it believable these documents has been executed?
That I will clarify that the impounding of the document will not mean that the document has become genuine.
That is
That is the law. It is not on genuineness.
That is for the
Genuinely, my lord, the documents of old documents 40 years before.
What my learned senior saying is that that is the probative value.
No.
That will be decided later.
What I submit, my lord, the documents.
Mr. Datto,
I have shown
I
documents.
cannot set aside the order of impounding. That is correct order. Impounding order cannot be interfered with. On what ground will I interfere? A document which is unstamped, it is placed before the court. The document is required to be stamped. What is the purpose of impounding? Mr. Datto, what is the purpose of impounding? The only purpose is so that the revenue which the state has missed is brought to the state.
Before impounding, the genuinity of the documents.
No.
Because 40 years document, which will be produced after 40 years.
Genuineness of the document is not required to be tested before impounding. Show me the law on this.
If that be so, then I can show this because
show me the law. I'm keeping it tomorrow. Show me the law because I know it just the other way around.
If your lordships allow the impounding, then due to that reason, my execution will be.
No, that I will observe that it will not stay. The court will not stay.
But you also observed earlier. But kindly visualize this thing.
Very well. I cannot merely because you want it to be done that way. I will not say that impounding is bad. Impounding is proper. Impounding I cannot interfere. Order 1 Rule 10.
But in the order itself, can't you see the order number 220?
Very well, Mr. Datto. Then you bring the judgment. I will deal with that.
Only one thing.
Yes.
Kindly see the order number 220. 220.
Yes, I've seen the order. You have placed it yesterday. I've seen it.
But this order is there until this.
I will clarify that. You show me the judgment so that I also get enlightened because my little knowledge is that genuineness is not required.
That is absolutely right, my lord. I have got the latest judgment.
After impounding, that is the law which I know. You show me something else.
No, kindly see the order 220 order.
I've seen it. I will say that execution case will not be stalled because of James case. I will say that once again.
No, until my lord, this is the impounded, the James case will not be touched.
So that will not stall your execution. That will not stall your execution. You show me the judgment.
But then you also clarify it.
I will clarify it, but you also show me the judgment because I will not leave it half-hearted. I also want to learn because that is not. I have learned. Show me
impounding my lordship. Documents. No, only one.
Tomorrow I am keeping it.
No.
I'll pass the same judgment tomorrow, but after considering the judgment which you want to show.
Then will you also kindly
Mr. Datto, learned advocate appearing for the petitioner, hands up to court. Lots of factual problems are there. Difficult. That is difficult. Legal is also difficult. Only if Miss Bhattacharya can do something.
My leader in this matter, my lord, now today morning accepted the pro forma. I said that I will not appear in the court.
Item two. No, in any case, you have seen the facts. They are
Definitely,
ugly,
yes, my
ugly
lord. I
facts.
cannot improve, my lord, whatever is there, my lord.
Because in any
These
case,
are a matter of records.
because of lack of bona fide, it will go.
And my lord, also, my lord, as officer of the court, 89 degree at one point of time, it must come to an end.
Yes, yes. I will finish it.
Item
To do it today, but Mr. Dotto wanted impounding also.
Definitely,
Otherwise, I would have sent it for a toss today.
Justice Lahotti's judgment is there, my lord. There are two parts, my lord, of marking of evidence. One is admissibility and, my lord, one is probative value.
Probative value.
Admissibility at this juncture.
The first one was Pachal.
That is 2001. Yes. Then, my lord, Justice Lahotti clarified.
Considering that Lahoti is Justice Lahoti is just. The impounding will not require genuineness to be first ascertained, but you satisfy yourself so that you don't have a glitch in mind.
Great.
Item 2.
Yes, passed over. Call for it.
I'm sorry, my lord, last occasion I cannot find my affidavit service. This is the fresh
Yes.
affidavit service. Kindly go through the one
That is
track.
why I said now this is complete. You have seen the difference.
Yes, yes. The difference is, my lord, is return to the center. Door
Yes.
locked, return to the center.
Very well.
Now this judgment is applicable. What I am saying.
Very well. Likhun. You are a tenant.
I am a tenant.
Affidavit of service filed in court today is taken on record. The affidavit of service reveals that the
That's why I am annexed the Malad plain. They are Malad trying to avoid this service. Plain copy is Malad, page 24.
page
23 and page 21.
Page 21, yes.
Malad Mithu Pal.
That is your plane.
My plane.
Not plane.
No, no, no. This is Milord. No, this is my executive magistrate. Plain copy is here, Milord.
Where is your
Just a minute. Just a minute. Milord, yes, yes, yes. I'm got it. Key diyeche একটা দাঁড়িয়ে পড়ে। Plain copy posted lines. Milord, page 24, Milord. The Girish Park, Kolkata 700 and the is numbering 10. Don't know, Milord, what ভুলভাল দিচ্ছে।
You don't have the plane's copy in the application.
Plane's copy.
It is insufficient address is not good service.
Insufficient code is not a good service, but Milord, the plaint, I am maintaining the address, the word is mentioned in the plaint.
There is nothing on record to
Plaint
show
is not
that.
here. Plainter copyটা এখানে দিয়েছিলাম সেটা এক্সিকিউটিভ ম্যাজিস্ট্রেটের ফার্স্ট কথাটা এটা আছে ইয়েস আই হ্যাভ দ্য কপি অফ দ্য প্লেন সরি এইচ
Their mobile number is also given in the plaint nowadays.
Plaint, no mobile number was given. It's out of our state, that has been given. But here, only the in Vokalatnama that has been given. What can I?
In the plaint, you in your plaint, mobile number of the party is also given.
There's a share code advocates. Oh, now it's a mandatory. I have informed.
Yes, likhun. Affidavit of service filed in court today is taken on record. The affidavit of service reveals
Under item 19, I am praying for 2 weeks accommodation. That I'm led by Mr. Siddiqui, he is out of station.
My lord, I appeared on behalf of CAC on the last occasion, my lord. Your lordship had directed them to take an instruction. It's a case of splitting of load, my lord. My lord,
Kindly 2 weeks accommodation.
Learned advocate appearing for the petitioner seeks an adjournment. Full stop. List this matter in the combined.
My lord, I am here. 28. There is nothing to say for the private respondent as well. May I just very briefly, in just 2 sentences, indicate what is the issue? Over my wall, the private respondent is trying to get the electricity connection through my wall. So that is the whole issue involved. No, really sought for, and the service was done a long time ago also.
You also sought for time on earlier occasion.
Yes, but may it be then not on Monday only. Monday I'm not here.
This week. Not this week.
Not this side. Deeply obliged, Lord.
My lord, I am for the petitioner, my lord. On the last occasion, my lord, leave was granted to file a supplementary.
Lord, I appear for WBSCTCL, we have no objection to
Which is
provide connection.
Which is already prepared, my lord, but has not been performed yet due to certain medical emergency of my client. Allow me for only for this week, my lord. I will serve the copy.
This week.
In between, yes, my lord, and come back.
Not this week already.
Grateful, lordship.
Next supplementary affidavit may not be required, Lordship. We can dispose of.
Last time it was leave was granted. How can I say not required? Next.
Grateful, lordship. Grateful.
Next.
Grateful, Lordship.
This is my petition, my lord.
My lord, Deputy Mukherjee appearing WBSDC, my lord, short Passover praying.
Passover. Next.
Passover will be called after.
Whenever you are ready, both of you are there. I'll call otherwise.
I'll catch hold of him. I'll try to catch hold of him.
23 Lordship, I am for the WBSCTCL. My lord, in this matter, my lord was pleased to come for a report on the earlier occasion, Lordship.
Who is appearing for the petitioner?
Lordship, the report is regarding, my lord, the petitioner had alleged that the other side, the private respondent, they have started to draw a line by hooking, Lordship. That was their more or less allegation. There was an earlier allegation as well to that effect. Lordship, we have conducted an inspection, Lordship. This is my report. Take to kindly then.
Not found.
Lordship, no. Lordship, we have conducted an inspection, Lordship, and on the basis of that inspection, Lordship, it has been observed that at the time of inspection of unauthorized hooking not found at the location of such and such. And here was Lordship was trying to use his another connection which is already registered in his name. He was trying to draw a line from that connection to this connection.
Oh, so he was
Lordship.
using his own.
However, we have undertaken inspection and we have already.
If they find hooking, they will take steps. I'm disputing it.
Lordship may pass necessary.
My lord, he has taken the line from hooking.
They have conducted inspection. They have
after
the authority, sir. You are not the authority.
After direction, my lord, they have disconnected this.
They will keep a vigil. If he's found hooking, they will disconnect. Report filed on behalf of the.
What report?
My lord, I am appearing on behalf of the WBSCDCL.
Yes.
Yeah, sorry.
For the petition. That
TCL, my
matter,
lord.
your lordship
Sorry.
knows.
My junior Mr. Roy is there.
Yes, he's there.
Yes,
He's
yes,
there.
yes, my lord, I could see.
Well, last occasion, your lordships taken up this matter when they, my lord, proposed to the petitioner for settlement in respect of the compensation they will give. My lord, they also issued notices. My lord, item number 24 and 26, same matter. Notice was issued, but till date, they have not, my lord, given any compensation. Despite notice.
My respectful submission before your lordship would be that unless the work is completed, it will not be possible to ascertain they are entitled to only damages. So damage could be ascertained only after the work is
Yes,
completed.
Mr. Salahuddin, he has a point. Mr. Panja says that how much damage you have sustained,
Lordship.
that will be able to be determined only after the work is completed. Because
Lordship.
maybe in the process of work you suffer more damage.
Yes.
Now, if they give you some compensation now, then another damage is suffered, then another compensation, then there will be several rounds. So they will wait till the work is concluded. After the work is concluded, they will ascertain the compensation and pay if you are entitled to payment. That is what his submission is.
1 minute.
ওরা কি বলেছিল কাজ হয়ে গেছে
না কমপ্লিট হয়নি
I will dispose this off.
Now, my lord, my humble submission before lordships, as they have issued notices to the petitioner.
They will take decision on that on hearing you after the work is complete.
Yes.
So that they can determine the compensation. Because
Lordship.
keeping this writ petition pending will serve no
My lord,
purpose.
my humble submission that the petitioner may not be deprived.
No, that I will observe that if the
Lordship, that is my
is entitled to compensation, he will be paid compensation in accordance.
Yes.
Your entitlement has to be proved.
Lordship.
Yes.
This is 1 minute. They have issued notices for taking compensation.
Yes.
So that already it was proved that they have taken my land.
No. I am not the owner of the land. I am
After hearing, they may come to a conclusion. I will not preempt that conclusion that yes, you are entitled to. If they say no, you have a remedy. I will not from here decide that you are entitled to or you are not. That decision is open. They have given you notice for a hearing, you go and appear.
Lordship. My lord, another submission. This notice which they have given, that should be noted in the order sheet.
Give me that.
That is in page number 18.
Okay, it's there.
18.
The writ petition complains of arbitrary action on the part of the respondent WBHTCL.
Yes.
Is erecting poles, POLES, on the petitioner's property for drawing overhead transmission lines. Full stop. Paragraph. Mr. Salahuddin, learned advocate appearing for the petitioner, submits that page 18.
Page 18, P2.
That a notice dated June 29, 2026 had been issued to the petitioner.
Respondent number, Mala 3.
By the divisional engineer, within bracket E, Joynagar, Camp Office, WBSCTCL, stating that necessary compensation will be given to the petitioner as per prevailing acts and rules. Full stop. He submits that despite such notice, no compensation has yet been paid to the petitioner. Full stop. Paragraph. Mr. Panja, learned advocate appearing for the respondent WBSCTCL authorities, that it is too early to complain that compensation has not been paid to the petitioner, inasmuch as, the work of drawal, DRAWL, drawal of transmission lines is not yet complete, full stop. It is submitted that the petitioner's entitlement to compensation and the amount of compensation, if any, payable to the petitioner would be determined only upon the work of drawing transmission lines being completed, full stop. It is submitted that therefore, the petitioner's grievance at this stage is premature, full stop. Paragraph. Heard learned advocates appearing for the respective parties and considered the material on record, full stop. Since it is not in dispute that the work of transmission line is still work of drawing transmission line is still underway and is not yet completed, therefore, at the moment, no fault can be attributed to the WBAC TCL authorities in not granting compensation to the petitioner, full stop. It is evident from the notice dated June 29, 2026 that the WBAC TCL authorities have said that necessary compensation will be paid to the petitioner as per prevailing acts and rules, full stop. That is therefore, it is clear that if the petitioner is entitled in terms of the prevailing laws, then the petitioner would be paid compensation, full stop, in accordance with law, full stop. In such view of the matter, a WPA 16658 of 2026 is disposed of, leaving the petitioner free to approach the WBAC TCL authorities with its request for compensation and leaving the WBAC TCL authorities free to take appropriate decision as regards petitioner's entitlement and amount of payment of compensation in accordance with law, full stop. WPA 16658.
One prayer may I make, lordships, after completion within certain time,
it is expected that the petitioner's request for case for compensation would be considered by the authorities as expeditiously as possible and preferably within a period of 6 weeks from the date of completion of the drawing of transmission line.
Grateful, lordship. Grateful.
Lordship.
Lord, if you lordship take up this matter, 26 matter.
26 একসঙ্গে দিয়ে দিন একবার, ওটা এই ফাইলটা দিন একটু সুবিধা হবে।
Lordship.
26 টা একবার কল করুন।
Only date of notice is different.
Case 24.
একই জিনিস হবে, নোটিশের ডেটটা একটা 29 জুন বলে একটা লিখেছিলাম না,
Case 24 annexure P3.
এটা হয়ে যাচ্ছে আপনার 22nd জুন 22, 2026।
Yes.
ঠিক আছে, বাকি সব সেম।
And the WPA also
WPA
separate.
he will check.
Lordship. Grateful, lordship.
Thank you.
Dispose of.
Grateful, my lord.
Thank you.
Great.
Grateful, lordship.
Lordship, my lord, 25, again, my lord, direction given, and we have served the copy. One have accepted, other refuse, affidavit service. Same, 2 times I have.
My lord, I am for the CAC Limited.
My lord, here, Darana Bolidi Shishkur. Here, petitioner is the consumer of electricity, but he has to apply a fresh for shifting of the meter. For that, petitioner paid the security amount and quotation money, and they complied with all the formalities. But due to objection of the private respondent, CAC could not the effect. We are ready to get police, we are ready to pay police cost, my lord. Let that.
Shifting of
Shift.
supply.
Yes, my lord, because so far he is getting the electricity from his brother's meter of the same premises, but right now he has got the fresh electric connection in the same premises in his occupied portion, and that's why he has applied for the fresh electric meter. It's a paid case. Our authority went to the local to execute the job, but they got strong resistance from the private respondent, and that's why you need the police help. Without police help, we can't proceed. We can't execute our job.
Co-owners, you are co-owner, no?
I am the owner. My premises, they are a part of they are the neighbors, just beside our house.
None appears for the private affidavit of service filed in court today is taken on record. Full stop.
Milord, I am for the CS.
তুমি কার হয়ে?
Lordship, we are for the state, that's what.
আমি CS.
Oh, CS. Lordship is a case for disconnection. The petitioner lordship is a tenant under the trust, and he is running his business there. Suddenly, the respondent number 5 has applied for meter in my premises, where I am in possession. He is not in possession. And immediately after getting the knowledge, I made an representation to the petition, CSC page 24 onwards. Is a representation.
Is supplied to be disconnected.
Despite that, they have installed the meter there, lordship.
He is in possession of the property.
No, lordship. This is shop room. I am in the possession. I am a tenant
Yes,
under a
Mr.
trust.
Ghosh,
My lord, this 350 feeder road is a large industrial commercial plot, my lord, and measuring about 40 to 50 bighas. The petitioner, the consumer has approached us for a commercial loop.
for the consumer. You are appearing.
No, he's for the state.
Who is appearing for the private respondent?
I have made them party and service completed, lordship, page 10.
So, my lord, the applicant is an occupier of a shop room. My lord, admittedly, in the area where there are 6 and 7 other common establishment who are deriving connection, my lord, from a common meter box position, which is around 40 meter away from the petitioner's shop. And my lord, thereafter, we have asked for his possession, and
Yes,
a
sir.
trade license has been provided to
40
us.
meter away from here, how are you aggrieved?
Lordship, there.
Meter is installed at a place which is 40 meters away from your
No,
shop.
lordship, in my premises.
Position.
In my premises,
What is
lordship.
your premises? Who are you in respect of
I am
the
a
premises?
tenant under a trust, and I have run my shop room there.
You are a tenant under which trust?
Under page, lordship, the trust deed is 15. And the shop room and the
Just a minute, just a
16.
minute, page 16.
And the meter is installed in my shop room.
My lord, we have inspected.
And they have installed the meter in the name of the trust only.
No, lordship.
Yes.
In the
What? No, that
in
is
the name of the private respondent, lordship, they have installed the meter.
The private respondent has approached us for a commercial loop. My lord, as a proof of evidence, he has supplied us with a copy of the trade license. And my lord, we have been there, we had seen that and in the
Lordship,
same area,
kindly-
my lord,
lordship, kindly
there are
please-
5 on 6 other shop rooms who are deriving connection from a common meter box position.
Lordship,
which
kindly
is
come to
around
page
40
25
meter,
once.
around 40 meter away from the petitioner's shop room.
This is the
And only there, my lord, we have installed the connection.
They are the second representation, lordship, where categorically the documents have been stated, given there. And I request him there to verify.
Page 26, what documents have
Page
you?
25, lordship.
Page 25, yes.
Is the second representation for the trade license, municipal tax receipts,
Yes.
bank receipt, that is.
If it is a big premises,
It's-
50 people may have a
Is not
trade
precisely
license
so.
in respect of
Lordship, as I stated there, as I stated, it is not that there is a big place, there are several shop rooms. But 350 is my premises number and meter is installed in my shop room, lordship.
350
It is
feeder
not
road is
in the common place or
350 is the name of the premises.
lordship.
10 old post office trees. That's the
Lordship.
name of the premises.
Lordship.
You are the owner of one chamber there. You will say that at 10 old
If-
post office trees, nobody else should.
Lordship, if
It's
they,
a commercial complex.
if they install
350 feeder
the,
road.
lordship, if they install the meter in the common place, I have no grievance. But
It is
they have
there in the-
installed in my shop room.
No, no,
All-
no, no, absolutely denied.
Let them file
Absolutely
affidavit,
denied.
lordship.
Milord,
in that case.
Milord,
Let
absolutely
them
denied.
file affidavit.
For what? You show that there has been, it has installed, it has been installed in your shop room.
Let him come up with a photograph.
You show that it has been, a isolated meter has been installed in your shop
I'm
room.
com-
That is not how it works. It is always there in a building which has several meters. It is usually at a common meter board where all the meters are clubbed. That is how it
Then
works.
kindly fix
It
up the
can't be
matter
in shop room.
next week, lordship. I'm coming with the supplementary affidavit with the photographs, lordship.
Come with a
But
supplement.
my instruction is that kindly fix any date.
Let us see.
I'm coming.
Let, since
Item category 8, I beg to appear for the private respondents, my lords.
22 was passed over. Just
22, my lord, can it be not today, my lord? I'm requesting.
not today. Yes, 28. Yes, it will retain wherever it is.
Time for the petitioner. My lord. My lord, this is the affidavit of service.
I appear on behalf of WBS.
My lord, I am the lawful occupier of my father's land. And my lord, I got no objection from my father to start a lawful business. And my lord, I obtained the trade license from the concerned authority. Thereafter, my lord, I applied for electricity connection. But my lord, till today, no connection has been given, my lord. My lord,
Mr. Mukherjee, why are you not giving him connection?
I will kindly come to page number 16, annexure P4.
Page 16, 16.
Yes, this is my letter dated 30th of March 26, my lord. We have categorically submitted that there are certain objections, my lord, which we have faced by the alleged co-owner, my lord. We have not got any relief.
Yes.
Well, may I? Well, before I even go into the question of merits, kindly takes paragraph 4 of the writ petition for a moment. Because if a statement has been made from the bar and there's an averment in the writ petition that a trade license has been obtained in respect of the said property. Your lordship kindly sees paragraph number 4. Your petitioner states that the father, namely so-and-so, is the actual owner of the land being so-and-so, dark number 154. Malaj will kindly take the next paragraph, para 5. Petitioner states that the father of the petitioner provided no objection to the petitioner if the petitioner wants to start any lawful business over the said land. Malaj will kindly mark this. Now your lordship will kindly take the trade license that they've annexed, Malaj, at page number 13. This is in respect of a different land altogether. An impression is being given to your lordship that this is in respect of the land that they are seeking a electricity connection for.
Number 200. Where do you want your supply?
They want it at dark number 154, Malaj.
You have no objection to 200.
No, I do have an objection. Malaj, both are Bastu lands, they're residential lands, Malaj.
Then, my lord,
high tension line cannot run over there. They are asking for 154, my lord.
High tension they won't give. They will give low tension.
We are not giving high tension lines, my
High
lord.
tension lines are not given for supply.
What we propose to give, earlier there is already a distribution transformer which was there, which was carrying the load of 25 kVA. My lord, it reached to the height of 63 kVA, and the petitioners are applied for a commercial load of 10 kW. In view of the, my lord, we have to install a new DTR substation, my lord, along with low tension support poles. For that, we need that road, my lord. Nothing more, nothing less. We are ready and willing, my lord. It has been.
Is there a problem with regard to way?
Yes, my lord, paragraph page 16, my lord, will come.
The way is what? Commonly owned?
Yes, my lord. My lord, kindly come to page,
not commonly
page 16, my letter, my lord, that is, my lord, 30th of March 26, my lord.
Yes.
My lord, kindly see, my lord, that the objection has been raised by Sri Harishadan Satra, Sri Monorayan Satra and others, claiming that the proposed service line is intended to pass over or through a property plot number 154, jail number 17, which is under the shared ownership. According to the representation received, there are concerns regarding the right of way for the proposed electrical infrastructure. The applicant, as per WBSC procedure here and the terms mentioned.
Connection may be given by all.
The applicant is responsible for providing clear way permission and
if there are issues with regard to way, why don't you approach the district magistrate?
I will direct. I will direct.
You should have approached. It's your responsibility.
I know, but let there be a formal order.
There is a formal order. I asked Prasad Malas, he wants to use it for commercial purposes. The electricity connection is also for commercial purposes. But there's no commercial license that has been obtained. Even the license that he is proposing to show before your lordship by way of this writ petition is pertaining to a different property altogether, Malas.
So that property he can seek it. You want it at 200 or 154? Where do you want?
Malas, the prayer is for 154 and he's annexed a copy of 200, my lords.
Then, my lord, I have to.
He's making an impression before your lordship that he's obtained trade license for 154.
No, my lord, then, my lord, it is maybe my fault, my lord. My lord, I need to take instruction.
Take instruction.
Either 154 or 200.
Very good. Take instructions.
Because I annexed
File an opposition and at least bring these documents on record.
Because if there is a question of right of way, Malad, if there is a dispute, let me at
If
least
there
show
is, if
Malad.
there is a dispute, this court will not decide. It is settled. If there is a dispute, that has to go before the district magistrate. He is the authority to decide because Mr. Mantha, under section 43, the right to electricity is a concomitant of right to life.
Yes.
So the court will not shut out electricity.
No, but this is for a commercial purpose he's asking for it. That is where I'm
Even that
raising-
commercial purpose is also right to do business.
Yes, but
So that is also Article 19
I bow down.
fundamental
I
right.
bow down. Let them take instructions and come back.
Yes, let them take instructions because usually courts don't shut electricity rights. I have a right to take electricity because life is not full without it nowadays. It's like putting off water.
Yes, I bow down. I bow down.
लिखे नहीं. A learned advocate appearing for the petitioner seeks time to take instructions.
Next matter is shifting of meter from different premises. Our premises is 243 by N and meter installed along 243 by B, just beside the house. So that building is demolishing now. In order to solve the problem, we applied for shifting of the meter. We are ready to comply all the formalities. We are ready to pay the necessary charges. And my learned friend,
May I? But so far it is the two different premises. Though the bill has been made of 243N, but admitted position from paragraph 5, your lordship will find that it is the meter is lying in 243B, but it has been wrongly written. It is 243V, not B. It should be 243V. Now, what happened, your lordship? There cannot be shifting from one premises to another premises. A new connection has to be drawn. A new cable has to be drawn. If they're subject to compliance of all formalities, we are ready and willing to do.
we are ready, my lord.
But shifting cannot be done because in a one premises, it can be done. But so far from another premises, a cable line has to be drawn. Your lordship is aware about that.
We are ready to pay that charges. No problem.
And that old meter will be taken out from the 243.
The writ petition alleges
Good
enactment
training,
on the part of the respondent WBSCDCL authorities in shifting the electricity
giving liberty to mention.
Give it, it will appear. It will appear.
No, notification. Today pro forma has come. Everyone has signed it. So it is expected tomorrow the notification will be released. That what is the rumor of the part. Now, my lord, I am the petitioner. On last occasion, I was arguing, and my lord, just to refresh your lordship's memory, the petitioner before your lordship, my lord, applied for new connection. My lord, he was getting connection, electricity from the landlord. It, my lord, a HT connection. It's a big premises wherein, my lord, at least 400 commercial units are there. This is one of the units. So the principal contention raised by the respondent in the affidavit in opposition is that first, the entire premises should be construed as the premises. And the second is, as the LT connection, HT connection is there, HT connection cannot be supplied. So, my lord, to counter the first argument, I have placed a judgment of Supreme Court before your lordship.
That it should be read as supplied to the consumer only and not to the premises.
So now thereafter, the second issue, my lord, I am first addressing the point of law, and then, my lord, I will go to, my lord, the factual issues in respect of whether, my lord, LT connection and HT connection can be given. So, my lord, last occasion, I placed a judgment before your lordship. Herein, my lord, there was divergent views between two single bench. Now, my lord, there was a divergent views. HTLT. So first judgment was, my lord, of 2003 volume 4 CHN 541. To diye dao, just, my lord, take it as officially placed, because thereafter the matter was referred to division bench. So I was relying on the judgment of division bench. Ek minute to diye dao 2003 4 No, it's Namina. Well, may I hand it over? Well, just 2003 volume 4 CHN 541. Now, the issues are at paragraph 27. Acha, 2003 volume 4 CHN
paragraph 27.
542. Yes, 27 is the issues. 541. Well, lordship sees the issue whether it is really difficult for the respondent CSC Limited to supply electricity to different consumer to separate service connection in the premises wherein prospective consumer are possession, whether respondents limited can ask the to make payment. So first issue is, my lord, relevant, and, my lord, lordship, important paragraph, just 2 paragraphs I will place. Now, my lord, lordship, please kindly come to 43 first. Here, my lord, section 12 was quoted, and then, my lord, in 47, the power to make regulation was there, and, my lord, now straight away, kindly come to 53. Under Electricity Act 2003, no licensee, including CSC Limited, can refuse to give supply to the owners or occupiers of premises, and the owners and occupiers have the right to obtain a separate supply. This is a statutory right given under the Electricity Act 2003, and it is not open to licensee, including CSC Limited, to render the statute ineffective by relying on condition of supply framed by it. Now, my lord, 56. In the aforesaid circumstances, there cannot be valid technical reason to deny separate connection to industrial units such and such. And then, my lordship will find, for the aforesaid reason, I am of the view the authorities of CSC Limited should not refuse supply to electricity to such and such. Then 72, accordingly, the respondent authority of CSC Limited are directed to effect supply of electricity to such and such. So the issue was HT connection was given and whether LT connection can be given. So this is the judgment. Now
when the divergent views appeared, the matter was referred to a division bench. And my lord, it's an unreported judgment. I was placing it on last occasion. It's my lord, Bhaskar Pal versus the Calcutta Electric Supply Corporation. Now, my lord, straight away, my lord, I place the entirety. I don't waste time. My lord, kindly come to last 2 pages of the judgment, because earlier pages I have already, my lord, submitted before your lordship. Here, my lord, before that, at my lord, page 8, lordship will find section 53 was referred to, and my lord, also, my lord, this is very important that they may argue that point. Central Electricity Authority measures of safety and electricity award thereof provide supply and ensure supply lines were. So it was referred, it was considered the safety, and thereafter, this is very important. Well, I am placing these 2 pages, last 2 pages. It is manifest from the last 2 pages. It is manifest from the aforesaid provision. It is a primary duty of the distribution licensee to ensure the safety and security of the life and properties of the consumer at his premises by maintaining the electricity supply line where fittings. Even Regulation 7.2 of West Bengal Electricity Regulatory Commission cast a duty on the distribution licensee to keep the wire and meter if installed at the pole with proper insulation in order to avoid accident to happen. On a conjoint reading of the aforesaid provisions, including obligation cast upon the distribution licensee to supply electricity to the premises, it admits no ambiguity that that safety measures are required to be adhered to avoid any danger to life and the property that may occur because of supply of electricity. In the grab of sale, very important, the distribution licensee cannot deny the separate electric line and the premises jointly used by several persons when accessibility and feasibility can be secured there. There is no provision contained in the Act and the related rules or regulation that there cannot be more than one supply line in the premises, but obviously safety measures are required to be adhered to. There cannot be, very important, a blanket proposition that the moment a premises has been created with the supply line, no separate line can be provided there. Even in case of a similar premises, if the supply line can be effected, having accessibility without overlapping. This portion I am going to place from the fact, without overlapping the wire or laying the wire in a very close proximity or other related factors which may endanger the safety and security of life. Kindly mark this portion because this is my way out and I am going to place it. The connection of CSC that in a small premises more than one supply line cannot be provided. It is not acceptable as it depends upon location, accessibility, feasibility, ensuring the safety and security of the life and property. There is no distinction made while assessing definition to a premises in relation to its area. Therefore, it is difficult on the part of the distribution licensee to consider any premises small or large. The distribution licensee, being the creature of statute, is not permitted to import something within the provisions, nor can construe the provision in conservative manner, having cascading effect. We thus answered the reference as follows. There is no fetter on the part of distribution licensee to give a domestic service connection through a separate limited meter boards in respect of joint property, safety, security, life, property ensured in the regulation indicated above. I'm pausing here for a moment. One point of law I want to argue further. Here, the judgments of our Honorable Court has said that a statutory consumer has a right to get electricity. Now, that is statutory right. This is a fundamental right. But I will add further, considering my case. But I, as a consumer, also have the right to get the electricity at the tariff decided by the Tariff Commission. That has not been decided. I want to argue that. Now, here what happens? It is becoming very convenient to them to give HT connection to a big premises. Saying that it's convenient, I cannot give any. Now, when the per electricity unit, according to tariff order, is 9 or 8, I am buying it at 10. So I say that is also my right to get the electricity at the tariff decided under the act. So I want to go a step further. Now, so these are the broadly two propositions of law that I argue. Now, kindly come to the affidavit. Of affidavit in opposition of them. Now, before I placed the affidavit in opposition, some portion of it. Now, kindly come to page 17. It's an annexure, impugned annexure of the affidavit in opposition. Affidavit in opposition filed by
page 17.
Page 17. Oh, it's very interesting. I have argued on it on earlier occasion. No inspection report has been disclosed. It's just their word, and I will place judgment on that effect later. But kindly come to their stand, and then I will take your lordship to the evidence. Now, kindly see 15 September 2000. We refer to your recent representation regarding conversion of mode of supply of the above high tension to low tension. It would inform you that inspection was carried out in the premises of your representative when it was observed. Premises under reference has around 900 individual commercial establishments. I'm sorry, I just told 400. All of which being presently catered through HT supply through Messrs. Poddar Limited. Now, very important, the access load requirement of the premises stand at around 15 kilowatt. It is also recommended that such quantum of load can be catered to bulk HT supply. From safety and reliability point of view, we would therefore advise you to continue draw power from service. So it is not only safety, they say it's also reliable. Now, kindly see the affidavit in opposition, and then I will place to judgment and I will conclude my argument. Now, kindly come to paragraph 6 first. Now, 6, your honor, lordship will find it appears from the awareness that the petitioner has serious dispute with the registered HT customer. So that is the first. Then, lordship will find in paragraph 1, they said, in the last of it, that seek a separate HT supply from the same premises. And now, Roman 4, the licensee has refused to provide separate meter supply in the name of lead petitioner on the ground that the same will be hazardous. It is the license obligation to ensure that the safety and security of the lives and property of the inmates of the relevant premises is not compromised by effecting supply thereof by way of petition. The petitioner seeks to enforce the right to get electricity premises upon endangering the lives of the property. But then your lordship will find in the end of it is fire hazardous will be a strong possibility. Then, again 43 was relied upon, and then 8, in the event an application for conversion was received, such and such after carrying out site inspection was unable to accede to the request to such and such. Why it's not given? Then it is also stated, this is important, that while inspecting the office space of the lead petitioner upon receipt of the application, the answering respondent learned from the president of the building association of Poddar Court that lead petitioner, despite having taken entire 6th floor, this is important because I will carry on business in a separate floor of the Poddar Court on rent, last 5 years had not been paid the electric charges to the submitter. So, 2 things, 6th floor and submitter. Then, therefore, building association has disconnected the supply. He never had the authority to have consultation with my other side in absence of me. Then, lordship will find it is evident from the conspectus of the aforementioned perusal of petition such as. Why it is hazardous is not stated, and then, my lord, lordship will find that paragraph 8, hardly any place left in the premises to carry out lay any electric installation equipment to the effect electrical. Then meet such and such high tension. Then, my lordship will find said HT supply, kick line, respondent, and this is it, man. Now, the point I want to add before your lordship is that, my lord, why is the exact reason? Why is the exact reason for the hazard is not stated? The inspection report is also not submitted before my lord. This is a serious thing. My lord, now, my lord, lordship kindly have the affidavit in portion of jural portion. My lordship, at paragraph 4, the statements made in paragraph 1 to 6 are true to my knowledge. Those in 8.6 are. So paragraph 7, page 15, has not been even referred to. And basically that is their submission. Like, my lord, it was hazardous and reliable. So, my lord, basically, and also a ground was made initially, they have not given, so that is why they will not give. That is will from page 60. Now, my lord, here I want to, before going into technicality of the case, my lord, I want to place, my lord, two judgments on the issue in a writ proceeding. They are bound to give it. Now, my lord, kindly have a look at inspection report to substantiate their fact. I am relying on a judgment reported in 1988, volume 4, SCC, page 534. Volume 4, SCC, page 534. Now, my lord, kindly, yes. Kindly come to paragraph 13. Just one paragraph from two judgments I will say. As has paragraph 13, my lord, as has been already noticed, although point of profiteering from state has been pleaded in the writ petition before the High Court as an abstract point of law, there was no reference to any material in support thereof, nor was the point argued the hearing of the writ petition before us. No particulars, no facts has been given in the special writ petition or in the writ petition in any event, but the point has been sought to be substantiated at the time of hearing by referring certain facts stated in the application. In our opinion, well, this is important. When a point which is ostensibly a point of law is required to be substantiated by facts, the party raising the point, if he is the writ petitioner, must plead and prove such facts by evidence which must appear from the writ petition, and if he is a respondent, from the counter evidence. If the facts are not pleaded, or the evidence in support of such facts is not annexed to the petition or the counter affidavit, as the case may be, the court will not entertain the point. In the context, it will not be out of place to point out in this regard, there is a distinction between pleading under Code of Civil Procedure and writ or a counter affidavit. While in a pleading, that a plain or a written statement of facts and not evidence are required to be pleaded. In a writ petition or in counter affidavit, not only the facts, but also evidence in proof of such fact have to be pleaded and annexed to it. So the point that has been raised before us appellant is not entertainable. But in spite of that, we entertain such and such. Now, the second judgment. So, they say, all they say is their submission. This is, my lord, AIR 1968, Supreme Court 1413. May I? Not only one paragraph of this. As a matter of fact, part of one paragraph. What should the paragraph starts from 5? So, my lord, kindly come to page 5 and the first portion only of page 5 of the judgment. Page 5. Possible find page 5, the top portion only. Mr. Gokhale, however, argued that it was not part of appellant's duty to produce the accounts unless he was called upon to do so. And the onus was upon the respondent to prove the case and to show that the Dargah was of plot owner of such and such. We are unable to accept this argument as correct. Even if burden of proof does not lie on a party, the court may draw adverse interference if he withholds important documents in his possession which can throw light to the facts of the case. It is not, in our opinion, a sound practice of those desiring to rely upon certain state of facts to withhold from the court the best evidence which is in their possession, which could throw light upon the issue in controversy and rely upon abstract doctrine of ownership of goods. So this is, my lord, so two things, my lord, as they are stating, it cannot go as submission. It has to be, my lord, by way corroborating evidence that that person indeed went there, did an inspection, and the inspection there was a conclusion arrived at that, see, if I give you a separate LT connection, then it will be hazardous for you. Because that is, my lord, the ratio of the single bench as well as division bench. So it is not absolute thing. You have to prove from the fact that yes, due to this reason, I am denying. So my two dice are carted. Now, my lord, now coming back to my lord, the technical part of it. Okay. Now, my lord, there are two facts, my lord, kindly is necessary. Three facts, my lord, bullet point, as my lord, a layman, I am submitting for the lordship. Now, my lord, it's a big premises, Poddar Court. And the 6th I reside, or the television channel runs from 6th floor, which has 16,000 square feet. Now, so he said at 900 commercial units are there. I am at 6th floor. The transformer is at the ground floor. It's not that the electricity connection has to come through the ground floor and then go up. So the transformer is in the ground floor and my premises is completely separate in the 6th floor. Now, my lord, how it is different and how I used to get, my lord, I used to get through a separate metering system. So the electricity connection basically from ground floor by where comes to my premises, and there, my lord, is a separate unit through which I get my electricity and how it is recorded. And I have disclosed in the writ petition that, my lord, exorbitant charges are per month, 1 lakh more charges have been taken. I have agreed to that. But to the point, my lord, why I agreed to that, well, there cannot be any waiver to my statutory or fundamental right. But be that as it may, the transformer is in the ground floor. I am at 6th floor. I have 16,000 square feet. Now that cater, my lord, electricity from a separate metering system. Now, how there is, my lord, possibility of overlapping of line, and how there fire can, my lord, incident of fire can occur, and it is not, my lord, is not coming to our normal prudence. Now, my lord, if the question of, my lord, the last point, technical point they can take, that see, there is a transformer in the ground floor, I cannot give you a transformer. My lord, kindly come to my affidavit in reply. Affidavit in reply, I have clearly stated and also given pictures. Well, there are two transformers. One, well, lordship will find at page 17. Page 17, if your lordship kindly take. My lord, here this transformer is just adjacent to my building, and one, my lord, the another one is just 150 meter away, and 150 meter away from the building. Feet. Sorry, feet. So it's 150. One is 100 to 150, and one is just adjacent to that building. So from that, my lord, directly my lord, LT connection can be provided to the 6th floor directly. Now, my lord, here lordship will another thing, my lord, I am thankful to my junior. My lord, there is separate wiring, separate main switch, separate submeter. So the entire system is different, and it's not that it's, my lord, I am a tenant, I am sharing the floor with another tenant, my lord, there will be overlapping of lines. No, it's not that. And in the affidavit, they have said. So, my lord, here, and also, my lord, so here, my lord, on the conduct of CSC, my lord, therefore, I will go back to, my lord, paragraph 17, where page 17 of the AO, where they say, from safety and reliability point of view. So, my lord, which one? My lord, we have to give, my lord, the extra advantage for safety or for reliability. My lord, from the affidavit, there is no inspection report. So the question of safety is not there, is not proved, but reliability is proved. That I am giving electricity to a consumer and he is selling it. Now, my lord, there are, my lord, against, my lord, there is another sub point to it. My lord, likewise, my lord, I submitted before my lord, that here I have a right to get, my lord, the electricity at the tariff fixed. Now, my lord, there is also a duty, my lord, they cannot encourage on, my lord, distribution of the other person, private individual. That is also a sub issue. My lord, kindly come to section 54. 54 of the Electricity Act. My lord, kindly see section 54.
Yes.
Save and otherwise exempted under this act, no person other than central transmission utility or state transmission utility or a licensee shall transmit or use electricity at the rate of exceeding 200 on other volts in any place. So, this is their duty, to supply electricity to everyone. He cannot encourage a private individual to supply electricity. And here in annexure, the earlier annexure, page 716, I have to paste it because here, all of them at one point of time, page 16 of their evidence. Lordship will find we have facing huge difficulties in current times to collect building maintenance, electrical dues from all 400 offices which are in the building. And our team is also facing harassment in this regard. Since this has been going on for some time, our association in their recently concluded meeting has anonymously agreed to have for conversion HT to individual. One thing, it was denied. It was denied. So they are saying, I am denying. How can you deny it? How can you encourage a private individual to supply to 400 or 900, whatever are the consumers? Can you encourage this? This is against the legislative intent. The statute is clear. A distribution licensee can do it if there is no open access, if there is no captive electricity generation plan. It is the duty of the distribution level license to supply. Now, one point, I never asked for conversion. I asked for simply stated LT connection. So I am completely separate unit and I want that. So to conclude here, my submission, to conclude my submission here, this is also a different mode of eviction. I am not going to join issue on this. Is essential supply. To conclude, I have statutory right. I have fundamental right. And my lord, the LTHT one is not, my lord, a mandatory thing, that it cannot be. My lord, that has been held by the single bench as well as the division bench.
Alternative.
And my facts and circumstances, as my lord, I am running as a completely separate unit in a separate floor. I think, my lord, this is my submission, that, my lord, there should not be any hindrances to provide. And, my lord, considering when, my lord, the employment of so many persons, I think, my lord, I am praying before your lordship to provide electricity connection to me. No, I am grateful.
Alternative ব্যবস্থাও আছে।
কি বই জাজমেন্ট করবি? হ্যাঁ আমি জানি, দিয়ে দেবো তুমি শুরু করো।
Just to distinguish, I don't want to take it further. No, my lord, the writ petition is asking for supply of low tension supply. Asking for low tension supply, where high tension supply exists. Lord, I will go into the factual aspect for later on. But kindly come to page 7 of the writ petition. My lord, page my lord, 6 paragraph small j. The writ petition is, however, not in respect of the illegal disconnection by the private respondent, inasmuch as there was no solution in the conciliation process among the petitioner, its employees, and the private respondent. The petitioner applied online for new electric connection with the respondent number 1. Then the respondent number 1 duly inspected the report. This is a paragraph probably duly inspected the property number 22nd July 2026. After the inspection, then your losses will find the submissions made. My lord, I do not find any averment that they denied my inspection. Physical inspection, the petitioners have not denied. My lord, we have refused the high tension line exists. LT line we have refused because high tension lines. In our affidavit, we just narrate the grounds or the reasoning for why this was refused, elaborated. The main reasoning is there. High tension line exists. And therefore, why the high tension line exists, low tension cannot be given, I have explained it. My learned friend didn't ask for the inspection report at any point of time, even in the writ petition. He said that the inspection was done. The my learned friend cannot now say the inspection report was not annexed, all that. He admitted that. We explained the technical reasons in the affidavit why this cannot. But before that, your losses kindly take up section 43 of the Act. No, new Act. Old Act. No. Thank you. My lord, subsection 1, section 43(1). Save as otherwise provided in this Act, every distribution licensee shall, on an application by the owner or occupier of the premises, give supply to electricity to such premises. My lord, I get a judgment from my learned friend cited that the premise supply is given to the consumer. My lord, the whole matter was in regard to, my lord, whether it creates a charge on the property or not. Because after, my lord, HON'BLE lawsuit knows all that. Still, that is affirmed, I find. By this Act, the Supreme Court holds that the electricity dues doesn't create charge on and over the property. In that way, my lord, the Honorable Supreme Court decided it. But I'm on a little different point. My lord, a premises belongs to me. I'm the superior landlord. He's the lessee. My lord, before he comes into the premises, my wisdom, what am I to do with my premises? I'm giving an example. It's a superior landlord. He was not in the premises. He applied, give me HT supply. I'm the supplier. I give him HT supply. The supply was given to the premises. My duty ends. Either consumer or your lordship's premises. Either consumer or occupier. But I have given to the consumer of the premises. Since I have subsequently become an occupier in respect of a portion of a part of the premises. But before he enters into the property, someone has taken the supply. So my duty is to give supply either to the premises or to the consumer. I have given. You are enjoying supply. So you cannot say that this I have not given supply. Lord, I respect the right of the citizen that he has a right to enjoy supply. But that is not absolute right. This is, my lord, circumscribed by the provisions of law, certain technical norms. My lord, this is an technical act. It doesn't conceive all the provisions. When you say comply with the, my lord, maintain safety and security, cast duty upon the licensee. So it is upon the licensee to decide which is better for security and which is better for safety. It's not for the intending consumer to dictate. Unless he can show scientifically that this is wrong, this technical reason. My learned friend has not been able to show any scientific reasons that what I am said on affidavit is wrong. But at this point, just this short point was, I find in one judgment in Justice Joint Commission. Do you have a copy? My lord, I just read out and I hand up a copy. My lord, Akbar Reza versus CSC Limited.
2007-1 CHN.
CHN 528. Oh, yeah. My lord, I just my lord, I just read out. I will give to. Oh yes, yes, yes. My lord, kindly hand up. No, just a minute. Oh, what? My lord, kindly, just a minute. I have. No, no, down page. But ignore my pencil marking. সব জায়গাতে পাওয়া যায় এই কানুন ফানুন যায় মানে kindly see the petitioner alleges inaction on the part of CSC saying that it has not given independent supply of electricity to him, though as a tenant of the premises concerned he has a legal right to get such supply. In the opposition filed by the third respondent, landlord of the petitioner, it has been stated that after entering into the premises in the year 1988 till the year 2004, when the application seeking independent supply of electricity was made, the petitioner did not consume any electricity through the existing supply line of the premises. There is no dispute that a high tension supply line given to the premises by CSC was and still in existence. Counsel for CSC submits that there are about 200 establishments carrying on their activities from the premises. He says that the transformer, probably your lordships has hurriedly gone through this. But kindly come to 7, 8, and 9. I am unable to agree with him. The interpretation of the provisions of section 43 of the Act 2003 as sought to be given by the counsel for the petitioner, if accepted, then in my view an absurd situation will arise. Section 43 in my reading and understanding provides for supply of electricity to an occupier of the premises when such occupier is not in a position to enjoy electricity. The occupier is already in a position to enjoy electricity supplied to the premises, is not entitled to seek enforcement of the obligation of the licensee simply because he wishes to get an independent supply. Duty cast upon the licensee must not get such an unreasonable interpretation. I will try to read between the lines. Then your lordship, section 8. Section 43 does not confer any absolute and unqualified right on any occupier of the premises to get supply of electricity. Such a right is, if such a right is visualized, then the interpretation is bound to lead to an unworkable situation. In the present case itself, the interpretation may lead to similar demands by as many as 200 establishments. Already that was done, my lord. Maybe by the association or that. that prayer was made. Such demands, if are to be made, then the resultant situation shall undoubtedly throw the whole existing supply system into disarray, and the landlord will be reduced to an absolutely insignificant person. I cannot ignore that the petitioner entered into the premises with his eyes open. If he has disputes with his landlord, he is at liberty to get them settled through the appropriate forum. But on the facts, there is no reason for the Reed Court, essentially a court of equity, to grant him any relief. Needless to say all that. But I am on paragraph 7 in interpretation. What I am trying to impress upon your lordships, he knowing that this is existing supply and supply is there, he entered. I have gone through their lease agreement. I have not found any provisions giving them any right to them. So, my lord, knowing full well, you entered into the premises. And then you say, give me independent supply. Apart from technical reason, you are already in a portion of the premises. My network exists. Internal wiring belongs to the consumer. That's true. But it goes through my commencement of meter supply point. It goes to you. So this is not a dispute between the landlord and the occupier. That's a different aspect. You have to settle yourself. Because having known the facts, you have entered into this. This is one aspect of the matter. My lord, his right is not absolute. That I am occupier, give me supply. My learned friends, read the judgment all. Your lordships will not find these facts in any of the judgments. None of the judgments your lordships will find the facts. Judgment has to be read on the basis of the facts. I will take, that's why, my lord, all the judgments, your lordships. Now, your lordships, what I have said. Kindly have a look at my affidavit. My lord, I will be only on the relevant portions. My lord, kindly consider paragraph 5, page 5, continuation of paragraph 3, Roman 3 of paragraph 7. The premises is a stand-alone building. Lord, this is not a campus having several blocks. This is a stand-alone building. I believe my learned friend will not deny this picture, commonly known as Poddar building. This is stand-all building. This is highly congested area. Everybody is fighting for space. Joseph, kindly see, my lord, how the commercial spaces exist in the premises. This is the only stand-alone building. 400 units are there, according to my affidavit. I give my learned friend. My learned friend says a beautiful picture. Take it.
আগে ছবিটা ট্রান্সফরমার দেখা যাচ্ছিল, এটা দেখা যাচ্ছে
Now, your losses, or the point I am trying to your losses, stand-alone building. Now, my lord,
which paragraph you referred, Mr.
My lord, page 5, continuation of paragraph 7, Roman 3.
Yes.
If it premises is a stand-alone building. Immediately, the next paragraph, Roman 4, well, learned friend has pointed out, the licensee has refused to provide a separate meter supply in the name of the writ petitioner on the ground that the same would be hazardous. Lord, we have said then we went on, my lord, why this will be hazardous and it will be compromising with the safety and security. Now, your lordships, kindly consider, my lord, page 6, Roman 6. Lord, what I submitted and support of my submission, I cited a judgment. Your losses, kindly consider that. The obligation of the licensee to provide individual connections would cease to exist in a situation when providing such individual supply would lead to a chaotic position or a position of absurdity, or would tend to amount to compromising safety and security of the persons residing in the premises concerned in the relevant locality. Well, learned friend has cited because of the several my lord, contradictory judgments, the division bench judgment presided over justice stand on. My lord, that was, my lord, in respect of LT supply. Service, two service connection in the same building. We deny, my lord, normally deny two service connections. Two service connections of the same nature. LT, we often deny. But your lordships, I can, my lord, fairly submit before lordships, in a building, that's praying for two service connections. Service connections in the same premises, in a, I'll refer that, I'll refer that. Not I will take your losses to that judgment, but I'm just saying your losses. The two service connections, in respect of that, this judgment comes. I will take your losses in detail to that. Now your losses will find, we have said in paragraph 8, Roman 8, page 6. In any event, it is stated that on 24th July 2023, an application for conversion of the high tension supply existing at the Podda Court to low tension supply was received from the HT consumer and the respondent number 4 herein. However, after carrying on site inspection, the CSC Limited was unable to accede to the request of the HT consumer as conversion of the entire building into a low tension supply would require adequate space for installation of 4 new transformers and also sufficient space to install 26 new service connections apparatus which could not be provided by the HT consumer. Now, my lord, this is, my lord, as good as, my lord, 6 Roman. No, just I give you. No, 7 is. Now, my lord, new transformer. My lord, regulations are there. If you want to, space has to be provided for transformer. Sub-commission's regulations. Now, my lord, we denied it because of these reasons. Now, my lord, whether correctness of this decision, I'm not saying the my friend questioning this, but raised his voice also. The transformer, can it be done before your losses? That whether 4 transformer space is there or not there, or whether 4 transformer at all required or not, who will decide it? The licensee is the best person. I will cite the judgment on that. It's not for the Honorable Reed Court to decide it. But it's not a simple case that his portion is not at all supplied with electricity. He was supplied with electricity. But it is such a situation, my lord, where we cannot even give low tension separate supply to all. And that's why consumer initially applied for HT, we gave him. Then we will not get the meter positions also. Sub-meters, my lord, the difference is for them. It's not our meter. It's for arranging. It's not a question of supply of selling of electricity. I'm not selling electricity because high tension consumer. He's consumed for your convenience, he is giving it. You ought not to have entered into that premises because of the nature and character of the premises. But separate. Now, my lord, kindly see page 8 of reply in regard to this. Roman 8, paragraph 7. Oh, just. Roman 8 is over. Roman 8. No, ठीक है. My page 8. Malad, kindly see the last paragraph, last few lines, I think 6 lines, page 8 of the reply. I deny and dispute all allegations contained in subparagraph 8.
Yes.
Subparagraph 8 of paragraph 7 of the affidavit. It is denied that the petitioner has suppressed any material fact or otherwise disentitled. I say that all material facts necessary for arrangement have been fully disclosed. Then what is said, my lord? Paragraph 7, Roman 8. What is the denial? I'll stand corrected if I wrongly refer to your losses. What is the denial? What my learned friend asking it to adjudicate by this honorable court. So factually, my lord, we have said it. We said we got it inspected. You have not denied physical inspection. My lord, order should not be, should not contain all the reasons 1 by 2, 3, 4, 5, 6. I've given the main reasons to you. Then your losses will find kindly, my lord, page 7, continuation of paragraph 8.
Opposition or reply?
Opposition, I'm sorry.
Page 7.
7. 7, my lord, 7, kindly skip over, kindly straightway come to page 8, my lord. It's a continuation of paragraph 8 divided in several sub-paragraphs. My lord, Poddar Court 18 Rabindra Saroni, Kolkata is a G+8 commercial building consisting of 400 numbers of commercial units. All of the occupiers of the subject premises are enjoying electricity to the high tension supply registered in the name of the Poddar Udyog Limited, being HT consumer number such and such, for commercial purposes. Hardly any space is left in the said premises to carry out or lay any electrical installations and or equipment to effect any electrical service connections. The said premises is being made through high voltage bulk electric supply of about 51534 kVA for the purpose of catering to a load of 1534 kW. The high tension supply exists in the name of Poddar Udyog Limited. The fact that the writ petitioner's establishment is situated in the same building which is receiving HT supply, and that the writ petitioner entered the said premises knowing full well that the said premises is having HT supply, can be discerned from the statement made in various paragraphs from the writ petition. Then your lordship, the writ petitioner had initially approached the answering with an application for separate metered supply. That's my lord, the HT consumer. Such request of the writ petitioner was declined by the respondent for after carrying out an inspection on 20th July by a letter updated such and such. Presently, this petitioner has approached this honorable court seeking direction upon CSC Limited to provide separate metered low tension or low voltage supply in favor of the petitioner at the premises based entirely on the allegation that the private respondent has unjustifiably disconnected. Then your lordships, kindly G subparagraph 1. I state that the providing low tension or low voltage supply at premises where high tension or high voltage supply already exists is highly risk-fraught and hazardous. The dangers of providing low tension or low voltage supply at premises where high tension or high voltage supply already exists are enumerated herein below. Normally, one service line or one single mode of supply is provided at a premises for either high tension or low tension supply, and the same is installed on the ground floor at a suitable or common and accessible point. In case both low tension and low voltage or high tension of high voltage supply coexist at the said premises, there is a chance of backfeed or backflow of electricity which may cause accident and could be catastrophic. Coexistence of both HT and LT supplies in the same premises would mean coexistence of two different sources or mode of supplies. Such coexistence of two different modes would almost inevitably lead to intermingling of two sources, especially during outage of one of the two sources, either due to load shedding or due to some fault or for any other reason. This would be because one of the sources of the supplies goes off, the source of supply, which would be then continuing, would have to bear the total load of both mode of supplies. These would inevitably cause undue damage to the distribution system of the elastic. Intermingling of the electric supply from two different sources or modes of supply can lead to accidental paralleling of the high voltage supply with that of the low voltage supply. Then your loss is 4. In case of such paralleling of supplies, the consumer's installations will act as a busbar between the two dissimilar transformers of different size and capacity, which will lead to unequal load of sharing between the transformer and consequent high current flow through the consumer's installation, endangering the life and equipment of inhabitants of the premises. Then, my lord, we have given the all technical reasons the losses will find. Then your losses will find paragraph 12, page 12, paragraph Roman 9. In terms of the central electricity measures relating to safety and electricity supply regulations, it is the obligation of the licensees to provide at the commencement of supply a suitable lighting treatment with cutoff or breaker. Well, this everything has been provided. Then multiple modes of different voltage are allowed to in a single premises. Then no single operation device can be installed to de-energize. Well, kindly look, because this was Now, kindly look at page 9, paragraph 7, dealing with my paragraph 8.
Page 9 of opposition.
Reply, my lord.
Reply. Mr. Sanil, how long will you take? Because we'll be having original site from 3.
Then you kindly give me another date.
How long will you take? So
half an hour more.
I will just take 10 minutes.
But only, my lord, I request to losses, kindly do not take it on Monday. Monday I have.
Well, and make it part-hard, my lord.
Do that.
Well, probability of brain change, my lord. That's what I am saying, my lord.
Part-hard is dangerous thing. It can be taken up as well as anybody.
Agree করবো তুই এখানে চলে আস এগ্রি করে দেবো জাস্টিস তপব্রত চক্রবর্তী দিচ্ছে না রিজেক্ট করে দিলাম একটা 12 দিন শুনানি হয়েছে
একটু বলো তুমি বললে
Can you make it hard in part? Because I tell you, lawsuits, one matter I argued, and the Reserve Bank of India, before one of the for 12 days. I requested similar refusal. I told them, you know the procedure to do it. I applied, they consented. Even the Honorable Chief
Here
Justice.
he will consent.
No, my other side also
but
consented. Honorable Chief Justice rejected it.
Well, and only 40 minutes odd will be taken, my lord.
Several have been assigned to me already because of this only, because I have been in several determinations.
But in that matter, the Honorable Chief rejected.
Lordship is taking up assigned matters. আমার
Nothing
assigned
happened.
matter আছে 21 তারিখ 21 অগস্ট।
Heard Mr. Sanya, heard Mr. Nag, learned advocate, appearing for the petitioners. Full stop. He has concluded his
আমার
submission.
ছবিটা দিল না যেটা আমার চাই সেটা দিল
Mr. Sanya, learned senior advocate, appearing for the respondent numbers 1 and 2, has opened his submission but is yet to conclude. Full stop. Next week when? Tell me.
Tuesday, losses can keep it.
নেক্সট উইক মানে কত তারিখ হচ্ছে
Is this matter? Tuesday কিছু fix নেই তো?
মানে টুইসডে আই হ্যাভ প্রবলেম my lord কালি ফিক্স ইট অন আইদার মানডে
আমি থাকবো না
or my lord ওয়েডনেসডে
Do that, your losses. Wednesday. ঠিক আছে।
Thursday. We can have it on Thursday.
Thursday. Lordship.
On 13th August. August 13, 2026 at 2 p.m.
2 p.m.
Same time.
Gratefully.
এটা পুরনো লিস্ট রয়ে গেছে দেখলাম।
Lordship.
Yes.
Lordship.
স্যার আপনি
May I, my lord, my case was this PLP case was this for third hours, but some of my relative expired, so I could not attend the date. Kindly pick the same at your convenience, madam.
And may I permitted to mention through PLA matter non-consensual.
Lordship, may I be permitted to mention one probate matter, Lordship, where paper publication,
PLA.
paper publication has been. And
Lordship would recall, I came up with an application for examination of my witness on commission. Lordship, but Lordship has asked the witness to be present. Lordship, today was the witness action, but from the records I find that the judge's brief has not been filed, so those things have to be done, and the issues have not been framed. Lordship, today may I file the judge's brief, and Lordship may frame the issues. I have got the suggested issues.
So I have my suggested issues ready. Lord, I find out from the Lord records that initially the matter was fixed for settlement of issues. Thereafter, my lord, an application was filed by my learned friend that disclosure was not made, disclosure was made, and now my
Yes,
an application.
the same thing. The same thing. Lordship, the issues have to be framed now. My lord, I shall be filing my suggested issues. Lordship. And Lordship kindly keeps it then, my lord. Lordship, my witness, he came and Lordship, what happened, my lord, in the rain, he got drenched. Lordship, he's of advanced age. So, my lord, he's suffering from fever. He won't be available, Lordship. Kindly keeps it after, Lordship, 20th, my lord. Today itself, my lord,
I have my suggested issues ready. What I said,
Totu? Lordship, my suggested issues is on his way, my lord. Lordship, I do not want. Lordship. I shall just file. These are usual issues. Suspicious circumstances are there or not. Undue
one more thing is that I will also be filing my.
Suggested issues there.
I'll be also.
But you may file my suggested issue. Just come.
I'm also filing my documents. Documents for yourself.
Key documents.
যেটা ডিসক্লোজার হয়েছিল ওটা আমাদের ফাইল করা হয়। এটার কোনো কপি দিয়েছে। Documents on behalf of the defendant.
একটা document নেই।
Defendants.
তোমাকে একটা চিঠি দিয়েছিল। হ্যাঁ, আমার আগেই ফাইল। আমাদের Lordship, discovery inspection is completed. We have completed, and thereafter, Lordship, I'm filing my. My judge's brief ki diyeছি? Lord, finding my judge's brief of documents. Oh, sorry. And Lordship may frame the issues, my lord, as per the issues suggested.
there is no pressure for filing judge's brief.
It is
Lordship may see it is made as per their affidavit, my lord, the written statement. Lordship may frame the issues. They are the usual issues. Deख ना एक बार, এটা তো
My lord.
Yes. He has given the date of the will, 10th May 2013. That we have not given.
That's sad. So only the fact, yes, fact that the will, whether the will has been executed or not.
Lordship, on their, as per the written statement, Lordship, this has been made. There should not be any problem. দেখ না, যে না লিখুন। এটা ঠিক আছে। লিখেছে তো। নামটা দিয়ে দিই।
ওরটা বলা আছে।
তোরগুলোই দিয়েছি।
না, একটা খালি আছে।
কোথায় লিখেছি?
একই হচ্ছে। So only one thing that I want.
So we skipped it like 2 weeks hence. Returnable 20th. Lordship. Lordship.
By comparing both the documents, I find only the issue number 3 on my behalf, my lord, it's a little different. My lord. Copy.
তোদের সাজেস্টেড ইস্যুতে দে না।
ও, একটা কপি দেখ না আছে কিনা। না, ওটা বাইরে গিয়ে দিবি, মনে হয় নেই, ওটা বাইরে গিয়ে দিবি। My lord.
Yes.
To kindly consider, my lord, I am just found out that 3 is different. Kindly consider all.
Yes.
Just going through, my lord, cursorily, my lord, I found that 3 is a little different. My lord. After 3. After 3.
Great.
My lord, I am for the petitioner, my lord. My lord, one application has been filed, my lord, as GA1, my lord, for the withdrawal of this PLA application, my lord. My lord, it was filed by the erstwhile advocate, my lord, but but the client want to proceed with the application, my lord, right now, my lord, with the application for the probate. Well, I just wanted, my lord, the GA application may be not pressed, my lord, maybe withdrawn. But this is the inspection, my lord, I've got from the client. Yes, my lord, this is application for the grant of probate, my lord. Previously, a GA has been filed for the withdrawal, my lord. No, my lord. My lord, this is an application has been filed for withdrawal of the PLA, my lord. But now my client wanted to continue with the PLA, my lord. So I wanted, my lord, the GA may be dismissed, my lord. Yes, my lord. Yes, my lord. My lord. My lord. Wait, wait.
My lord, I am for the applicant. This is an application for grant of probate. My lord, I pray for an order in terms of prayer A and B.
Your Lord, out of the three legal heirs, one has not filed affidavit of consent. I am praying for issuance of Lord special and general citation upon that legal heir, my Lord. Prayers A and B of the petition. Probate. Yes, sir.
My application, my page 7, my Lord, prayer course in terms of prayer. My Lord. Page 3, my Lord. My Lord. All have given consent, my Lord. My Lord. Petitioner before your Lordship is the son of the deceased. My Lord. Father has died, my Lord. Mother has already expired. Yes, my Lord. Son of late बोला हुआ है ना. My Lord. In first paragraph, my Lord, I have already indicated Chandrakant Nandlal Seth, son of late Nandlal Seth. My Lord, that is there, my Lord. My Lord, at page 28 and page 32 and my Lord,
running page 28, my lord, that is the after the affidavit of assets. Mm, Nivant Seth and Nitesh Chandrakant Seth and Mitesh Chandrakant and Madhubala all have given consent. Mitesh nahi, Moch means executor. Hi, it is there, my lord. Nivan. Affidavit of assets. He is the witness of the will. Affidavit of assets, एक मिनट दिया हुआ था, उससे पूछो तो वहां पे मुझसे निवान मितेश चंद्रकांत सेठ attesting with the last will which has been shown to me annexed, it is the time of execution, memory and judgment. My lord, it is implied that he has, my lord, he has already Mitesh Chandrakant ना नहीं मधुबाला से श्यामल कुमार मुखर्जी विटनेस श्यामल कुमार एक मोच से किसका बोला subsequently my lord that is not tagged with my record, sorry my lord. देखो इसमें है क्या yes this is my lord এটা তো इसमें sorry my lord एक साथ में 2025 डिफेक्ट क्या कैसे को सिलाई करके इसमें एक साथ कुछ बाद हाँ ये टिकट में थोड़ा ये वकालतनामा भी दिया था इसके बाद ये
After Millard, the order of direction for citation, which was on 21st of August 2024. After that, Millard, after issuance of citation, Millard, nobody has filed the caveat, Millard, and there is an affidavit to that extent of the sheriff so far as compliance of this order dated 23rd of July 2025. Yes, Millard. Your Lordship, may kindly seize, Millard, there is an affidavit by the second officer of the office of sheriff. This was citation and Millard, publication has also been done, Millard. Millard will find there's an affidavit, Millard, 8th April 2025. ও আচ্ছা আচ্ছা না এটাও হয়ে গেছে এটা দেখে Millard, at paragraph 5, we have written, Millard, that there are no legal errors which are known to the executors. Paragraph 5, my lord, at page 5.
Minute, I am for the petition. My lord, the provision of section 283(3) of the Indian Succession Act, my lord, has already been complied, my lord, pursuant to the order dated 5th of March 2025. My lord, the other legal heirs, my lord, they have already filed their consent affidavit at the time of filing of this probate application. A will of the deceased mother, husband predeceased, my lord. I annex the death certificate, my lord. Page 20 of the petition. annexed as C. Letter C, my lord. My lord. Paragraph 7. Yes, madam. They have filed the consent evidence. Those affidavits were affirmed on 6th of March 2023. 16th of March. Julie.
Lordship, I appear on behalf of all the executors of this. Three executors, Your Lordship. Two sons and one daughter. Two sons and one daughter, Your Lordship. Your Lordship.
we are coming back. There was a previous order passed by Justice Mukherjee, where there was a direction upon us to make publications in to the vernaculars and Lordship on the notice boards. So Lordship, that has been done. And also the ad valorem court fees that has been paid, sir. Paragraph 5. Page 4. 3 Lordship is the predeceased daughter. Her legal heirs, their status is not known to us. So Lordship, that is why there was, if my Lord takes up the direction passed on the 4th of September 2025 by Justice Mukherjee. May I just place this? Yes. There is a affidavit in my Lord's brief. Lordship, it is affirmed by the second officer stating that he has taken necessary steps for publication and for executor is one of the, she is the second daughter. Sumita Anand. They have consented. Consent affidavits are already on. Yes. The right 100 years old. I asked my learned senior friend who is assisting me, Lordship, is there.
You properly speak, just properly speak, he had idea that TL has filed, your officer went to his residence.
Stating, Lordship, that she is. Yeah. Because if Lordship kindly takes up the. Monday. Because Lordship, if my Lord kindly takes up her consent affidavit, I am told that the consent affidavit persons from the office went to her residence and But I also, what the question that fell from my lord, I also inquired from my senior friend whether she's still there, but she's hale and hearty at 100.
আবার টিম সিরিজ খেলতে
সুপার হিরো মতো লাগছে। কোন সুপার হিরোটা দেখালো? She's a widow. All no change in it. One is a predeceased daughter, that is yes.
বলতে গেলে ধরো একটা লাইন বেঁচে গেল স্টেট সাকসেস
Fourth September. The consent affidavits have come from the
I'm very great.
Oh, mother.
That application for revocation of grant. We have concluded.
Well, Lordship, last occasion, I have told Lordship, these are judgment of Justice Bhattacharya. There is an notification in respect to transfer has been quashed, and the state has already filed an SLP before the Supreme Court.
And they are stopped.
So, by defunct, already there is stay in respect to all transfers. So, I was only praying before your Lordship,
Let my learned friend say that if the stay is lifted, they will not proceed to deal with the problem. Well, I don't understand. He says, your lordship has said, my lord, file your affidavit within 15 days. We'll hear it out.
I have no problem, but otherwise, I cannot.
No, they will never come there.
Because I cannot. Only I am praying before Lordship. The Lordship will fix a very short date. I'll come with the opposition. Lordship will hear it out. And in the meantime,
Registration of conveyance or sign.
Give me 10 days of time. 7 days of time also can be done. I'll try to complete it within 7 days. I'll come back.
Yes, but in the meantime, না ঠিক আছে এটা তো না এটা তো it will mean that the court is refusing me my interim relief. Yes, kindly clarify that position. So long as I am protected, because I don't want my learned friend to go and obtain an assent to the legacy.
This will not operate as
what has happened. Even if I want, I cannot.
No, that is a different matter. He can't.
Then if a lordship is in that case, the lordship will kindly record that the maintainability in respect to the application is kept open. I'll satisfy on the at the time of
finally.
My agreeing will something that should be an order of the court. I don't have any, but lordship will kindly record that. Late there will be an order of the court. I cannot.
And maintainability point be kept open. Maintainability point be kept open.
And this is the SLP. I have given SLP order. SLP is pending. And with my if your lordship kindly records that the point of maintainability may be taken at the final hearing.
That your lordship has already heard it, but I don't mind, my lord. Your lordship will consider it again. My lordship.
In respect to the application, whether he has any direct interest or is a direct interest.
Made the difference between title and interest, your lordship pointed that out. That's it.
That is the main.
In respect to maintainability point, Lordship has heard me on last occasion. In 2008, volume 4 SCC, probably it was cited by them only. I am also, pressing on that, relying on that judgment also, and 2026 judgment also I am relying.
Hey, Lordship has heard us, either my learned friend consents or your Lordship will consider the
I
matter.
cannot give a consent directly, whatever that.
That's it. Let's at least a prima facie.
Yes, then your Lordship cannot pass an entry one. Yes, yes. Yes, definitely. I should bow down. Very well. May I pray one thing if concerns to my learned senior friend also? I can come back with an affidavit, Lordship can decide it finally.
Well, that is exactly what.
Maintainability point. Only the maintainability point.
Fixed karo here in.
Why I am saying,
Well, we are going back and forth on this for quite some time now.
why I am
Lordship
saying,
kindly decide this question.
today,
Now, I also apprehend that now we'll have a change of determination also, or may.
No, your Lordship can make it part hard, I don't have any problem. I don't have any problem. Only one prayer, as today, they have made out a prima facie case. So based on a document, I have tried to impress on the court that that document, to that document, no right has, legal right is or no interest is flown from in respect to them. So even if, if I can make my argument in a very concise way, if my application for probate is not defective, I have made all stipulations under the Act and everything is done. He is claiming through a document, as per Registration Act also I have shown, to enter into a document. So whether he has any legal right, even if, or any interest, Lordship will, the interest. Yes, 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 yes. 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 Particularly done.
Whether he has the power.
Us. Then only one thing, my argument is based on that, whether he can always file a suit against me, Even he cannot be restrained from going to.
I cannot file a suit. That is what I've argued.
He can.
I cannot.
This is a probate court, only the probate court will confer whether the probate, the will is genuine or not. That is enough, nothing else. And prima facie, whether it's maintainable in the threshold also. It's starting from 60, but reliance can be made on 74.
The agreement to enter an agreement doesn't flow any interest as per transfer of property. So they clarify that.
We had shown 102 and 103.
74.
Yes.
Paragraph 74, if you 73 from, if I can start, yes, a strong reliance has been placed by Mr. Jetmalani on Nobin Chandra Shil versus Bhuvor Sundari Dev. Therein Phil J. interpreting section 242 of the 1925 Act opined that if any person can show that he was entitled to maintain a suit in respect of property over which probate would have effect, he possesses a sufficient interest to enter a caveat and oppose the grant of probate. Such a suit, however, in our opinion, must have a direct nexus with the estate of the testator and not to enforce the right in respect of the application of the estate of the testator under another will. Right to maintain a suit must be independent of the wills sought to be probated. No legal right accrues under an unprobated will except in cases where taking of probate is not mandatory. In Nobin Chandra Sil, the appellant therein had a direct interest in disputing the will. He had obtained a money degree against the testator. His share was under attachment. In the aforesaid factual backdrop, it was held. What is the meaning of expression person claiming to have any interest? It appears to me that persons claiming to have any interest must be persons having such an interest as would entitle them to maintain a suit in respect of a subject matter of such estate. Persons having, for example, such an interest. My lord got it, man? Yes. My lord, such an interest as according to the practice of the court of chancery would entitle them to file a bail in court of equity. In contents two competing passages, one rendered by White J and another by Field, it is not necessary to consider whether the case cited by the district judge is a good law, for it does not determine the question with which we have to deal. In that case, the parties opposing the probate were simple creditors of a person who was heir of the deceased, supposing the testator had died without a will, and supposing also that he had not adopted a son. In the present case, the appellants have a claim upon the immovable property left by testator, two of them as mortgagees of the person who, if the testator left no will, are entitled to create the mortgage, and one of the appellants as the attaching creditor of one of these persons. A suit which would be maintainable must have something to do with the estate of the testator. Inheritance by will itself may be subject matter of contention. Whether the interest claimed by the caveator is an established one or a bare claim must be satisfy the test that there exists an interest in the estate of the testator and the same is not adverse thereto. So in both the cases, there was a mortgage and there was a money degree also. তারপরে কোনটা প্যারাগ্রাফ 74 সব জাজমেন্ট গুলো বলেছে ইয়েস তারপরে হচ্ছে ইয়েস then paragraph 80 up to 83 all the judgments from there up to paragraph 83. So all the judgments have been all what is a bare interest and everything has been given. Now so lordship kindly takes 84 83 real versus bare interest test was considered in each of cases having regard to the fact situation obtaining therein. So my lord, if I stop for a moment, my lord, in all the cases the court has taken the example whether this is a bare interest or it's a direct interest. In my respectful submission, my lord, my learned senior friend producing a document is having a bare interest, not having a direct interest. Yes, ma'am. Opposing a grant, my lord, caveatable interest. Yes, sir. Revocation. So, my lord, if my grant has been done, so my lord, then my lord, in that case, my lord, if I can correctly, then my lord, but revocation, my lord, probably the year is very small. Expense. It's very little. Yes. Normally in revocation, my lord, may I ask this question to myself, my lord? Whether he has shown that any interest has flown in respect to me.
Well, please see my list, section 335 once. 332 and 335 of the Act. Well, 332 first, my lord, if your lordship will please see. Thank you. Assent of the executor or administrator is necessary to complete a legatee's title to his legacy. My lord, so my lord, my lord has to, my lord, perfect his title. My lord, that is what he proposes to. Now, my lord, please see 335. When the executor or administrator is a legatee, my lord, this is the case in this case. The executor is a legatee as well. His assent to his own legacy is necessary to complete his title to it in the same way as it is required when bequest is made to another person, and his assent may, in like manner, be expressed or implied. Now, my lord, he cannot, my lord. My lord, my lord, please see, my lord, the illustration. My lord, illustration make it clear. An executor takes the rent of a house or the interest of government securities bequeathed to him and applied to his own use. This is assent. So, my lord, once he applies it to own use, that, my lord, is assent in itself. My lord, here, my lord, there is a, my lord, medicine shop and he's, my lord, appropriating rent from the shop. My lord, if he today says, I am the owner, my lord, then he becomes entitled to the rent as well. My lord, today, the only question here is, my lord, your lordship is not, my lord, deciding it finally. My lord, the question that your lordship is now, my lord, being called upon to decide is, my lord, the thin line between, my lord, title and interest. My lord, what the judgments have repeatedly said is that you must have. My lord, let him not, my lord, that will prevent him from claiming title or asserting his title so far as, my lord, third parties, including tenants, are concerned. Well, that is no, not a question of transfer. Well, today it's not a question of, my lord, transfer. My lord, today, so far as this is concerned, my lord, he should not, my lord, assert his title to the property. My lord, what harm will it do, my lord, if he does not do it for, my lord, 10 days or 15 days? Well, like your lordship is, my lord, putting the question to me that he cannot transfer the property by sale or, my lord, lease or mortgage or otherwise. Well, I ask myself the same question that, my lord, today, if he does not, my lord, assert his right to the property for a period of 15 days, if, my lord, today he is prevented from, my lord, assenting to the legacy, either expressly or impliedly, what prejudice will he suffer? Well, at maintainability point, your lordship, my lord, if my learned friend had consented that let there be a stay order for 15 days, 20 days, your lordship will hear it out. I would have absolutely no, my lord, comment to make.
Subject to correction, well, I have only said, well, there are an order. I cannot do anything as of today. Well, it's like, well,
No, my lord, it is not a matter of, my lord, it is not a matter of, my lord, him, my lord, transferring. My lord, today, for example, the first floor, where if he gives it out as a monthly rent, it will not, my lord, fall within the definition of transfer. That is permitted. My lord, will he not, my lord, be prevented from doing that? Creating a third-party interest in the property by creating a monthly tenancy. Where is the bar on that?
Well, what my learned senior friend is, well, asking for, my lord. Well, as of today, my lord.
Yes. My lord, here, my lord, I have.
Yes.
Yes, my lord, it was granted, my lord, some time back.
It is from municipal authority for mutation.
That is also 2023.
21st August 2023.
Para 20 we have stated.
Well, application for mutation they had made, my lord, in August 2023. Well, thereafter, my lord, I went to arbitration. But at that point of time, I did not know about the will. Well, I'll just tell you, lordship, my lord. My lord, we have only said, my lord, it is in the course of arbitration that we came to know. My lord, that is paragraph 26. My lord, I can't tell you, lordship, that we have said anything beyond that. Yes, that's right.
Knowledge from 7th August 2023.
Well, lord, here, my lord, well, urgency is, my lord, sometimes a ground, perhaps not always. My lord, for example, my lord, no, my lord, the answer, the question is two, my lord, the prejudice, will it be irreparable? Well, lord, that is the only question.
Multiplicity of proceeding if he takes assent.
Well, I know, but my lord, ultimately there will be a multiplicity of proceedings. My lord, even if a third party squatter, my lord, trespasser sitting there, ultimately, my lord. Well, let my learned friend at least undertake to quote that, my lord, he will not change the status or character of occupation of the property.
Yes, yes, why not do? Well, if she wants to hear me out, well, in the meantime, nothing will be done. Well, that much I can give assurance. Nothing can be.
Then let that assurance be recorded. I am asking for nothing more.
It's impossible to do, well, anyway.
Well, not,
From
my lord,
today,
not
Mala.
change the possession or, my lord, transfer. The
Well,
transfer,
no
my lord, he
prudent
can.
person will come and buy this property.
No, my lord.
Even today.
My lord, today, even, my lord, your lordship knows, my lord, in these banking matters, my lord, what used to happen. My lord, tenants used to create it on paper. And then, my lord, we'd fight forever. But I'm not only saying, my lord, that assurance is good enough for me. I don't mind your lordship hearing of the matter.
Yes, yes, yes. The lordship can recommend. I have my specific instructions. Well, we are not going to do anything in respect to in the meantime. Nothing I cannot do, my lord. Well,
Well,
will
in Salt
anybody,
Lake, possession is transferred before, my lord, title is.
will anybody invest, well, in this property, well, when the litigations are pending, when there is transfer, well, stay?
On the maintainability point,
And my learned senior friend knows much better than me in respect to that position.
maintainability point, that's it.
Mr. Mitra. My lord, I went through the documents, my lord, and certain arguments have to be made, my lord. My lord, if my lord takes the affidavit in reply, my lord, the reason I want to show the affidavit in reply is because that is the first time where grounds for injunction have been made out and not in the application itself. No documents have been shown in the application.
Surrejoinder to that. You want to use a surrejoinder to that.
My lord, there are some documents that I would require to show, my lord. I would have preferred to, my lord, file.
Mr. Gupta, since those documents are new,
I leave it up to you.
well within his rights to seek an opportunity to file a surrejoinder because
My lord, I can only
leave it
file
up
a
to you.
supplementary
Surprise
affidavit. my lord.
documents for him.
Yes. My lord, I can only file a supplementary affidavit just to show the documents, my lord.
Surrejoinder to.
Very well, my lord.
Mr. Legal and advocate appearing for the
My lord, may I be permitted to mention one matter? Item number 43, it was fixed for hearing today. It's a reconnection of electricity matter where your lordship has directed to file report and they have conducted the report. It was supposed to be filed today, but unluckily the matter could not be heard today.
We heard Monday, not today, not tomorrow. Tomorrow we'll be having different lists.
My lord, there is extreme urgency, my lord.
Very well.
Tomorrow kindly lordship fix.
Monday. আর তো 2 মিনিট আছে একটা কল করুন যদি কেউ থাকে তাহলে হয়ে যাবে ওনারটা সোমবারে নিউ মোশনে দিয়ে দেবো তাহলে উপরে চলে আসবে নিউ মোশন মানে আসে
My lord, কালকে একটু দিলে ভালো হতো। সমস্যা খুব হবে।
My lords, seek your humble indulgence, my lords. My matter is item 47. It's an assigned matter. I am for the response.
Assigned matters will be taken up tomorrow.
Tomorrow. Okay.
That is why I refused him. Assigned matters will come up.
Item 30. No, I'm not 30. 47 is also here, lordship.
দিয়ে দিন যা আছে করে দিন মিনিট বাকি আছে তো এখন
How much time?
Yes. Last matter. No, if you all can continue, I can continue. I have no problem.
My lord has got no problem. Final assessment he is receiving.
My last occasion, my lord, you lordship, can see page number 24, my lord.
Page 24.
24. They are issued on 9/9, hearing date 11/9, and received the same date 11/9, my lord. The letter. So not given any opportunity of hearing, not given any chance to file objection, my lord. Against the provisional assessment order. This is my case, my lord.
11/9, it was served on you in 11/9 only.
Yes, same date, 11/9, my received.
Where do I get that?
Not
Okay.
given any opportunity of hearing and not given any to submit the objection, my lord, as per 126(3).
My lord, I have taken instruction. My lord, what happened, my lord? Notice was duly served on 10th. And my lord, his father attended the hearing and put his signature on 11th and admitted the claim. Whatever it is, now my lord up to very serious. His father, your father.
Not known, my lord.
He has attended the hearing, it will be false. Yes.
But then, my lord, I have verified the matter.
Earlier, that also informed him. He was not correct.
No. I'll take up the matter tomorrow, my lord. I bring the prisoner.
Not today. কালকে দিয়ে দিন উপরে।
কালকে 1 number. I bring the prisoner.
My lord, this may be reflected to tomorrow. I may not. Very well. That we have produced one letter to him for verification, if he wants.
লিখে নিন।
আমার একটা কপি দিলে ভালো হয়।
লিখে নিন।
ছবি তুলে নিন।
হ্যাঁ?
His father attended the hearing.
But
they can do that. Thank you.
Wait for
Ram